it too.
All right, members, we're going to reconvene. Some of you caught that on the floor of the House. I said we were going to re-adjourn. Good gosh.
I like that idea.
Yeah, no kidding. Yeah.
I second that, Mr. Chair.
Yeah, that wasn't a motion. So with that, members, I'm going to pull forward the A23 amendment.
Mr. Chair, you said A23?
Yeah, I guess these are going to be hard to find because these are on a smallish paper, but it's in that packet that has the 52, A52 on the top. So it's clumped in with that one.
They're small.
The 823, you said?
A23 amendment.
I got found on a big one.
You have it on a big one? How'd you do that?
Magic.
I found it.
And is there anyone going to move that amendment?
Mr. Chair, I'll move that amendment.
Representative O'Neill moves adoption of the A23 amendment. Representative O'Neill.
Thank you, Mr. Chair. So in the corrections subdivision, we talked quite a bit about corrections officers and in the struggle to not only in the keeping them safe and a lot of concern there, but we also talked about hiring and retention. And so this amendment was something that we had added to the corrections omnibus, but it doesn't appear in this bill now, so it's been removed. So I'm offering it again, and what it does is it brings up the correction officer starting salary to $19.95 an hour, because our starting salary currently is $17.90. So this is an attempt to encourage more officers to join and help, because we currently have 90 vacancies, and I know they filled a few. I don't know exactly how many, but I've been told that they have filled a few. But when we were talking about this initially, they had 90 vacancies that they had not filled. And so this is an attempt to get us a little bit closer to being able to hire a few more folks so that we have better safety in our prisons.
All right, very well. Discussion, members? If not, all in favor of the A23 amendment, please say aye.
Aye.
Opposed, same sign? No. Motion does not prevail. The A24 amendment?
Yes, Mr. Chair, I have the A24 as well.
Representative O'Neill moves adoption of the A24 amendment. Representative O'Neill.
Well, maybe this one will fare better with them, with your committee, Mr. Chair. Again, in corrections, we talk quite a bit about correctional officers and the challenge in maintaining and keeping them on the force. And one of the issues that particularly Representative Zuras was concerned about was the pay scale and how quickly you can go up the wage scale. And this would condense that to 6 years. And in some cases, it's taking them 12 or 13 years to get to the top of the wage scale. So that is what this amendment does, Mr. Chair.
Very well. Discussion, members? If no discussion, all in favor of the A24 amendment, please say aye.
Aye.
Opposed, same sign?
No.
Motion does not prevail. Members, with that, we're going to move to the A12 amendment. Yeah, we did them.
Mr. Chair, that's my amendment. I'd like to move the A12.
Representative Poston moves the A12 amendment. Representative Poston.
Thank you, Mr. Chair. The A12 amendment adds the language of House File 91 into the language. It enhances penalties for driving with an invalid license for repeat violators. And I will mention that this was in the Omnibus bill last year and was vetoed. And if you look at lines 2.23 through 2.31, that is the crux to the bill. That shows you some offenses that would go from a misdemeanor to a gross misdemeanor and the terms of that. So you can see that the gross misdemeanor would be if you had a collision resulting in a substantial bodily harm. as defined in Section 609.02, Subdivision 7A, or death to another, or within 10 years of the first of 2 prior convictions under the section. And at the time of the violation, the person's driver's license or driving privilege has been suspended, revoked, or canceled, or the person has been disqualified from holding a commercial driver's license or been denied the privilege to operate a commercial motor vehicle. I had an incident happen up in my neck of the woods some years ago, and I received a letter from a constituent, and I don't want to read the whole letter, but I wanted to go through a few bullet points of the letter with you. This lady wrote me this letter, and her 24-year-old daughter and 4-year-old grandchild were hit in a head-on collision by an 8-time violator of driving after suspension. 8-time violator. The offender was charged with another misdemeanor. So the offender was charged a couple $100 and a year of probation. The grandchild had 30 surgeries, spent 100 days in intensive care, and the medical bill was nearly $1 million. The daughter is now, the 24-year-old daughter now is a few years older, but she's still living in a nursing home in a vegetative state. So both of these people were hit by someone that for 8 times were arrested or stopped or had an accident when driving without a driver's license. So this bill is really asking to take this from a misdemeanor to a gross misdemeanor. And again, I'll mention that this bill has passed and then went into the omnibus bill that was vetoed.
Very well. Representative Pinto and then Representative Johnson.
Thank you, Mr. Chair. We actually have so I thank Representative Poston for bringing this forward. We actually have I think an even better version of this that's in the bill right now. So it's on pages 129 to 130 something, and it comes from a bill that was authored by Representative Considine, House File 1375, I believe. And actually, it looks like Representative Considine, I think, wants to speak to it, so I'm just going to step back, Mr. Chair.
Representative Considine, and then we'll go to Representative Johnson.
Thank you, Mr. Chair. Actually, yes, I spoke to this woman. She had sent me several emails, and we spoke on the phone for roughly an hour. And there is a provision in here where we are moving it up to a gross misdemeanor for, I'm not sure if it's exactly the same, but, and again, this goes back to one of the things I talked about was the fact that the gentleman that blew through the stop sign that killed my brother, my younger brother, was charged with a misdemeanor. In fact, went up and did a victim impact study, and the judge departed upward and gave him 30 days of house arrest. They didn't even take his license. So no, this is something I'm pretty sympathetic with. And I actually had a bill in 2015 that I named for my brother, but by the time it got back from the Senate, it had very little teeth, and I'm hoping this one has more.
I'm wondering, Representative Considine, if we might not ask our House Research staff to describe the provision that's in the bill.
Mr. Diebel or Mr. Johnson?
Mr. Johnson?
Mr. Chair, you're asking for a description of the new provision that is currently in the bill, is that correct?
Yes.
Correct.
Mr. Chair, members, the provisions that is in the bill right now deals with criminal vehicular homicide and criminal vehicular operation. In the language that's currently in the bill, if a person causes bodily harm, great bodily harm, substantial bodily harm, or death to another while driving on a suspended license, when that license is suspended for one of the reasons specified in the bill, and the person's driving conduct is negligent, then that person can be charged with a crime ranging from a gross misdemeanor up to a very serious felony penalty. The list of suspensions is identical to the list that is in this amendment, which was also in Representative Heinzman's bill. There are differences between what this amendment would do and what is currently in the bill. If you need me to walk through that, I can walk through that as well.
If
Please.
you would, if you'd be so kind, please.
And Mr. Chair, under the amendment, a person would be guilty of a gross misdemeanor if the person violates this section, meaning driving after suspension or revocation, and did so, and also caused a collision that resulted in substantial bodily harm. So it wouldn't matter why their license was revoked or suspended under that scenario. Under the amendment, there's a second scenario. If the person commits a third driving after suspension or revocation, no accident involved, just a third offense, then that person is also guilty of a gross misdemeanor if, at the time of the third offense, the person's license was suspended for one of these more egregious driving conduct cases. Again, no accident necessary in that particular scenario.
Very well. Representative Pinto?
Thank you, Mr. Chair. I just want to clarify then that what's in the bill right now is actually a higher penalty and more gradations than is in the amendment. In the amendment that's proposed, the A12, it's a gross misdemeanor if there's a collision resulting in death or substantial bodily harm. Under the bill, there's whether a collision results in bodily harm, substantial bodily harm, great bodily harm, or death, with steadily increasing penalties that go far beyond what's in the amendment. And I think recognizing our gut sense that somebody who is driving negligently and causing a collision and then not being allowed to drive at all is deserving of the kind of penalties that's set in here. So I would strongly oppose the amendment and recognize the situation originally described by Representative Poston is actually addressed, I think, very well in the bill from Representative Considine's original bill. Thank you.
Very well. Representative Johnson?
Chair Mariani, Representative Pinto, there's a big difference between the two bills. Yes, there's some parts of that's in here that I really like, but in this amendment, they don't have to hurt anybody to get those enhanced penalties. If they're caught driving after suspension with convictions, we don't have to wait for them to hurt or kill somebody. We can charge them ahead of time. I know you're not going to take this amendment, but I'm going to ask that you please consider parts of it to increase the penalties for those who continuously drive with a suspended or revoked or canceled driver's license.
Very well. Representative Considine?
You are correct. I was looking for people that hurt people. That was what I was looking to do. And again, I talked to Sue for like an hour. Yeah, that, to be honest, it was, yeah, people that hurt people is what I was after. So I didn't even consider doing the third time if they hadn't hurt somebody.
Thank you, Mr. Chair. Representative Considine, would you then agree with this language?
I would
support this language?
Representative
It
Considine?
hasn't done the, excuse me?
I'm just calling on you, Mr. Chair. I'm calling on you to respond.
Oh, I couldn't get what you were doing at. As this is the very first time I'd heard it, I would like to look at it and talk to you about it first.
Okay.
Representative Poston? Oh, I'm sorry, Representative Johnson, then Representative Dean.
Chair Mariani, but we discussed another issue a little bit earlier. Maybe we can take care of that issue if we can get it worked out at the same time on Tuesday.
Perhaps if we're back on Tuesday, my understanding something's changed relative to our conversation. I don't know if John has had a chance to talk with you or not, but I certainly wouldn't mind leaving not super late tonight. Representative Dean?
Thank you, Mr. Chair. And as I'm looking at this and as it's been explained, that, a third time or conviction of driving under suspension within a 10-year period would then raise that level to a gross misdemeanor. And we had lots of testimony in conversations about the issue of poverty and things of that nature. And I know we've made some, or attempting to make some changes here that would address some of that, but I'm concerned that this becomes much too large with those three within that 10-year period. And for that reason, I would oppose the amendment. But as I'm sitting here, I'm thinking that there's some agreement to continue to work on this. So I would just encourage that. But at this time, I won't be supporting A12. But I understand the intent, Mr. Chair. Thank you.
Chair Constantine?
Thank you. And again, the thing that I'm shooting for is the people that hurt people. And that's what, yeah, I'll talk to you about it, but I want to go after folks that are hurting other people.
Very well.
Mr. Chair,
Paulson, I guess you get the last word.
Mr. Chair, Representative Considine, I remember your story very clearly. And this is Representative Heintzman's bill that he carried last year and is carrying it this year, but not in this committee or as an amendment. So I will certainly withdraw the amendment, knowing that we could work together in the next few days to maybe draft something that is agreeable to both of us.
Thank you.
Thank you.
Representative Grosso?
Just briefly, Mr. Chair, and sounds like everything is being hashed out here, but looking at why wait till somebody gets hurt if we can do some preventive on the front side to try to avoid that very thing. I know that it's heartfelt. It's something that you've been working hard on. Work together, and I think you guys are going to find something that you're going to find some real good common ground on.
Mr. Chair, I'll make a motion to withdraw my amendment.
Thank you, Representative Paulson. Can you all give me just a quick second here? Okay, thank you, Representative Paulson. Representative Paulson withdraws the A12 amendment. I look forward to see what you all come up with up here. With that, then we will move to House File A14.
Mr. Chair, I'll move the A14 amendment.
Representative Lucero moves the A14 amendment. Representative Lucero.
Mr. Chair and members, people who falsely claim to be the victim of a biased crime do a disservice to real victims, to society, and waste time and resources of law enforcement. This amendment makes it a crime to falsely report a crime motivated by bias, and I would encourage a green vote. Thank you.
Thank you, Representative
And
Lucero.
Mr. Chair, I'd ask for a roll call, too.
And roll call has been requested. Representative Lucero, can you let us know whether there's currently a crime involved in false reporting?
I'm sorry, can you ask the question again?
Is it currently not true that it is a crime to falsely report to a law enforcement officer?
My understanding is that it is currently a crime, but what I was actually trying to get the answer to, and if maybe staff could answer, what is the current penalty for that?
Very well. Perhaps Mr. Johnson can help us out.
Mr. Chair and members, under current law, we're in section 609.505. It is a crime. A first offense is a misdemeanor. A second or subsequent offense is a gross misdemeanor. There is a subdivision 2 that involves reporting not false crime, but essentially falsely reporting police misconduct. And that is a gross misdemeanor, I believe, on the first offense. Yes.
Very well. And I'm sorry, did you have something more?
I was just going to add then, so the difference in is this makes it a gross misdemeanor on the first offense.
Representative Johnson?
A little bit of clarification. It still keeps falsely reporting a crime a misdemeanor, But if it's a bias crime, a crime of bias, then it'd be a gross misdemeanor and not just a normal falsely reporting a crime.
Right, I get it. So as I understand, currently, except for that one not carve out, but that one special circumstance, a first-time false reporting is a misdemeanor, a second is a gross misdemeanor. This language would say it's a bias crime. The first one is a gross misdemeanor. Quite frankly, I'm a little uncomfortable with your amendment. I think that bias crimes are the kind of crimes that oftentimes are very difficult for folks to come forward on. There's a psychological impact that often accompanies the awareness of a being targeted because of one's race, color of skin, or perception of that, et cetera. And so I would hate, frankly, to be able to create circumstances where we're creating even more disincentives for someone to overcome the shock of that circumstance. Representative Pinto, I think you had something on this?
Thank you, Mr. Chair. Yeah, I would agree with you in speaking against this. It's already a crime to falsely report a crime, and it seems to me that the maybe one particular incident out of the hundreds and hundreds of thousands or millions across the country accepted, the problem we have is not the over-reporting of bias crimes. The problem we have is the existence of bias crimes and potentially the under-reporting. And I don't know why we'd pick this particular crime to give an extra bump for falsely reporting, a penalty for that, as compared to the other possible crimes that are already captured under law for that. And so I would argue against it. Thank you, Mr. Chair.
Thank you, Representative Considine.
Thank you, Mr. Chair. I've seen a couple of these in the news over, I'd say, the last 10 years. I think in almost every case there has been, I want to say, extenuating. There have been other problems that the person has had, mostly mental illness. I can't think of a time when, like I said, I've only seen 2 or 3 of them in 10 years, but in each case, the person had other problems besides reporting crimes, and I would be a little bit reluctant to go after them. Like I said, that's just based on my own anecdotal, what I've seen. Every time I've seen it, they've had some other problems, and I wouldn't want to increase their penalties. Thanks.
Senator Lucero, you get the last word on this.
Thank you, Mr. Chair. So the history of crime motivated by bias in the state of Minnesota is when a crime is committed, it could be an assault, it could be any number of crimes, there's a penalty. Then, but if that crime is motivated by bias, it's the equivalent of being considered an enhanced crime. So there's been a recognition by this legislature that a crime motivated by bias is an enhanced crime. And so there is also a recognition that when there is a false reporting of crime, or of an offense, that's a crime, as we just saw. A first offense is a misdemeanor, and it goes on from there. Because this, a crime motivated by bias, has been given an enhanced categorization, therefore, the penalty then for, or what I'm seeking to accomplish, is the penalty for falsely reporting a crime motivated by bias also has that enhanced response to it. And we've seen, as Representative Considine is mentioning, I'm not sure, it wasn't clear if it was crimes motivated by bias or falsely reporting of crimes motivated by bias that Representative Considine was referencing. But nevertheless, we've seen crimes motivated by bias in the headlines recently. And what we have seen is a huge consumption of resources, law enforcement resources. And we want to ensure that in Minnesota, people are not falsely making accusations of crimes motivated by bias, which generate headlines and can create inflammatory situation. And so that's why I believe it's important that we recognize that and give it an enhanced penalty on the first offense and not wait till the second or subsequent offenses. Thank you, Mr. Chair.
Very well. A roll call has been requested. The clerk will, yes, you requested a roll call, did you not?
Yeah.
The clerk will take the roll.
Chair Mariani,
No.
Christensen. No. Considine,
No.
Dean,
No.
Edelson. No. Grossel,
Yes.
Howard,
No.
Johnson,
Yes.
Lush, Long,
No.
Lucero,
Yes.
Miller,
Yes.
Moeller, Nash,
Yes.
O'Neill,
Yes.
Pinto,
No.
Poston.
Yes.
Going back to the top. Moeller.
9, 7.
1, 2, 3, 4, 5, 6, 7. 1, 2, 3, 4, 5, 6, 7, 8, 9. Yep.
9, 7. On a vote of 9 noes and 7 yeses, the motion does not prevail. Members, the A19-0376 amendment.
Good. Chair, let me find my notes here. I believe that is my amendment.
Better right. We have a lot of amendments, and some giving us time to find them.
All right, Chair Mariani, that would be my amendment.
Very well. Representative Johnson moves the A19-0376 amendment. Representative Johnson.
Members, Chair Mariani, this expands the assault in the fourth degree for involving fire, to also include firefighters. Or in the section dealing with firefighters, emergency personnel, whoever physically or intentionally throws bodily fluids or feces onto a member of a municipal volunteer fire department while they're performing their duties. Also expands it to the corrections officers. Increases also intentionally, it's the assault motive by bias, school officials, community crime prevention group members, postal service. It's people that have to go in the public, do their jobs. They shouldn't have to be put up with this stuff. It's happening more and more. I think it's time we try to put a stop to that because it's a safety issue. These are individuals that have to be out in the public, have to be in contact with the public, and they are getting assaulted, unfortunately, too often. And it's time to put a stop to it.
Representative Johnson, as I read your amendment, you're adding the circumstances under which a felony would apply, and we're even creating an imprisonment term with a particular length of time. Do you have a fiscal note on this amendment?
I'm not sure if there was one performed or not. I know that, I believe this is the same bill that we had last year. But I'm not sure if we have one or not.
Well, Representative Johnson, this amendment concerns me because I think it's reasonable to expect that this is going to generate a cost to the state, and the amendment doesn't speak to how that's going to be covered. And so, Representative Johnson, I'm going to rule that this motion is out of order. Members, the A22 Amendment.
I'd like to move that forward, Mr. Chair.
Representative Grosso moves the A22 amendment. Representative Grosso.
Mr. Chair, this bill adds 2 public members to the post board, requires that 2 of the 4 public members of the post board live outside the Twin Cities metro area. And we've had some discussion about the differences between the needs in outstate versus metro. And just to point out something that is awfully glaring is that, you know, as a rural law enforcement officer, when you're out on patrol, sometimes it takes an hour, lights and sirens, to get from one end of the county to the other to answer a call. A lot of times at night, you're the only one on. The same with getting any kind of help. You better, there's a lot of times you're on a call. If you need help, it's going to be 35 to 40 minutes. So you better be able to hold your ground. And it's the same thing for the public, that what they have to deal with when they make a call. If it's an emergency, it can be a half hour before somebody gets there, ambulance, law enforcement, whomever. So the needs of rural Minnesota are different than those of the metro area. So, you know, what I'm asking is that we make sure that we require at least 2 of those people of the public that are on that committee be from the rural areas, so that they get a very good and solid representation.
Representative Grosso, I actually like your amendment. This speaks to a provision that I have in the bill. And so I'm going to accept this, or encourage folks to, well, I'm going to accept and encourage folks to vote for it. And the only thing is, let's work to make sure that the language actually works as we go forward. But I think this is a good idea, and I think you made cogent and important arguments on its behalf. Further discussion? That's it? All right. If not, then all in favor of the A22 amendment, please say aye.
Aye.
Opposed, same sign. Motion prevails, and the amendment is adopted. We are on A25, members.
I'll move that forward, Mr.
Representative Grosso moves the A25 amendment. Representative Grosso.
Roll the dice again here to see if we can get some more going. A25 Amendment, Criminal Sexual Conduct Statutory Reform Working Group. I'm going to ask that it be moved from the Office of Justice Programs to the BCA. Minnesota BCA are the experts in criminal investigations and know what we need to do to make our laws stronger in case so cases can be charged and prosecuted. So that is my request, that it be moved from the Office of Justice to the Minnesota BCA.
Very well. Representative Mueller?
Thank you, Mr. Chair. And I'm sorry I'm not supporting this amendment. This bill, for a couple of reasons, this amendment has the $23,000 amount, which we, in the author's amendment, approved to $34,000 based on the updated fiscal note. So the amount is different. But I also wouldn't support moving this out of the Office of Justice Programs to the BCA. The Office of Justice Program works with victim advocacy programs. They work with county attorney's office. They have victim advocates that are housed in many of the different county attorney's offices across the state, and they provide a lot of technical assistance and support. I've worked with them on a number of occasions as a prosecutor in the victim rights world. I worked with them on a working group, and they handled it very, very well. It had a lot of different sides coming together. I'm not sure that the BCA I'm assuming, hasn't even been asked if they would support this change. But anyway, for all of those reasons, I would recommend a no vote on this.
Representative Johnson.
Mr. Chair, members, I would actually support this amendment. Office of Justice is usually there. We've been using them over the years as a facilitator for grants, not to run the programs, but for grants. Yes, they do work with these groups because those groups are the ones that receive grants. But actually doing the statutory reforms, doing those things, they don't do that. BCA is the investigators, BCA or the Attorney General's office are usually the ones that have been doing these things, not the OJP. So, and I believe, I'm not sure if he's still here, but Superintendent Evans was here, he'd be able to answer that question, or they'd be able to handle that. Because they usually, in these working groups, BCA a lot of times provides the staff to run them. I don't know if Superintendent Evans is still here.
You don't need it. It's not
Well,
necessary.
Members, I'm trying not to engage testimony on these amendments. Let me ask the maker of the motion if he's had a conversation with the BCA about this.
No, Mr. Chair, not yet. Just I figure with experience, knowing what the working relationship that I have had with the BCA, that it seems to take the logical place to put this.
Very well. Representative Johnson, what?
Chair, just as a reminder, the appropriation in the written form of the bill had never changed. That's why we kept that's why it says 23,000, although the spreadsheet did, the bill has not, I don't believe the bill was ever changed.
Author's amendment.
I think it was Representative Muller's sharing today that changes in the author's amendment. And as the author of the author's amendment, I can verify that. Any further discussion? If not, all in favor of the A25 amendment, please say aye.
Aye.
Opposed, same sign.
No.
Motion does not prevail. Members, the A26 amendment,
Mr. Chair, that would be mine.
who's that?
That's Representative Nash moves the A26 and requests a roll call.
Representative Nash moves the A26 amendment. Representative Nash.
And would request a roll call as well, Mr.
And
Chair.
a roll call has been requested.
Yeah, so, Mr. Chair, asking for the sex trafficking investigation coordinator to be moved from OJP to the BCA. Again, I firmly believe that the BCA is far more qualified than OJP to do this, just by virtue of what it is that they do. So I would ask for your support and renew my request for a roll call.
Very well. Representative Pinto.
Thank you, Mr. Chair. I may turn the tables on Representative Nash just slightly in terms of questioning to find out what. So there's a coordinator of the violent crime enforcement teams that's contained within OJP. What exactly are you envisioning that this coordinator would do that would be better accomplished within BCA and rather than OJP?
Representative Nash.
And, Mr. Chair, Representative Pinto, so, bringing a law enforcement professional's eye to it, sworn peace officer, I just think that that's probably a better utilization for this very sensitive task. So that's what I envision.
Representative Pinto.
Thank you, Mr. Chair. And I wonder, I'm looking to where in the bill the language is that relates to this particular proposal. Maybe I don't need to, if House Research has the, well, actually, I guess I won't mess with it. So in the bill, there's a requirement that this actually be a sworn peace officer or a prosecutor or county attorney, a retired county attorney. And the role, again, is akin to the one that is, and I'm real familiar with this because I was doing this work for a bunch of years. Just to be clear, this is not somebody who's directing sex trafficking investigations. So there's a task force within the BCA. This is someone who's coordinating the statewide response from the perspective of public safety, working with the counterpart in Department of Health, who's the Safe Harbor Director, and the Department of Human Services. And wherever the language is in the main DE, I'm not quite sure where it is, but it lays out the responsibilities. It's really not directing the investigations of sex trafficking, but rather dealing with the sorts of things regarding training, community awareness, et cetera, that sometimes those task forces are being occupied in and not able to do the investigation. In working with OJP through the years on this, they have great expertise and are absolutely the right place for this work. And again, this is something I was immersed in this world for several years, and I can assure you that OJP is the right spot for that. Again, in parallel with the similar role for the task forces that investigate guns, gangs, and drugs, that person is in OJP. So if we're going to move this, we'd want to move that person too. So I'll speak against it, Mr. Chair. Thank you.
Further discussion? Very well. All in favor of the
I had asked for roll call, Mr.
I'm
Chair.
sorry, roll call has been requested.
Thank you, Mr. Chair.
My apologies. The clerk will take the roll.
Chair Mariani,
No.
Christensen,
No.
Considine,
No.
Dean,
No.
Edelson, Grossel,
Yes.
Howard,
No.
Johnson,
Yes.
Lesh. Long.
No.
Lucero,
Yes.
Miller. Miller. Moeller,
No.
Nash,
Yes.
O'Neill.
Yes.
Pinto,
Nope.
Poston.
Yes.
Going back to the top. Miller. Miller. Six. 610.
And 6, very well. On a vote of 10 noes and 6 ayes, the motion does not prevail. We are now on to the A32 Amendment. And I
Mr. Chair?
don't know if it needs to be offered, but Representative Lucero?
I was just going to thank you for, it does not need to be offered. I wanted to thank you because you incorporated this in your author's amendments, so this has been corrected.
Thank you, Representative Lucero. Then we are on to the A33 Amendment.
Chair Mariani, that would be mine.
Representative Johnson moves the A33.
Nope, I am wrong. It's,
Oh, sorry.
he just took my amendment.
Getting ahead of myself.
It's getting rough here, folks. Hang on to your amendments.
Mr. Chair, I was in a committee meeting where that actually became fighting words.
Representative Poston.
Mr. Chair, I'd like to move the
Very well,
A33.
the A3 Amendment, A33 Amendment.
The A33 moves the telephone CPR appropriation and rider language from the Office of Justice Programs to the Emergency Communication Networks. I think it's a great program, and I'm excited to see that this is going to get done. But like with the medical resource control centers, I think this is where this belongs.
Representative Poston, I get that, but I'm going to oppose your amendment. This is a one-time appropriation. It seems to me more in keeping with the OJP's work, where often they're going to be those one-time grants. I don't want to be able to burden the BCA, frankly, with having to administer this. And Representative Poston.
Mr. Chair, not the BCA. I'm sorry. It goes to the Emergency Communication Network.
And Representative Poston, is the Emergency Communication Network involved in one-time grant activities? I don't know. I honestly don't know.
I do not know either, Mr. Chair.
Well,
But they are the people that do this kind of work, so it just makes sense to me that it should sit there.
Don't bring people down to talk.
Right.
Is there anyone here from DPS that can help us with this? Representative Poston, you got me.
Okay.
Good evening.
Good evening, Mr. Chair, members of the committee. My name is Dana Wahlberg. I'm the director of the Emergency Communication Networks Division of the Department of Public Safety.
I think the question is, well, I think there's several questions here. You're familiar with the amendment?
Yes, sir.
And so the question is, I guess, ultimately is, does this make sense to be in the emergency communications network, 1 and 2, or your perspectives on that? And two, what experience or capacity do you have for handling a one-time grant reimbursement program?
Mr. Chair, members of the committee, in response to your first question, yes, logically this should reside within our division. We have a training and standards coordinator that is employed through our division, and the person serving in that role would have some operational oversight and quality assurance and a training component to help manage this program as it's described in the original bill. So yes, that would make sense. And second, because we are funded exclusively through a special revenue fund with 911, we do not typically receive money from the general fund, so we do rely on a number of grants, particularly federal grants, many of which are one-time, and we do also have a grants coordinator that is housed within our division to manage those sorts of things.
Sounds like you have the capacity to do this.
We do,
Representative Poston,
sir.
I think I stand corrected, and it sounds like we should adopt your A33 amendment. Oh, very good. And I'm also told the advocacy group is not opposed to adopting the A33 amendment. So, very well. Final word?
I would just appreciate your support, Mr. Chair.
You got me, Representative. All in favor of the A33 amendment, please say aye.
Aye.
Opposed, same sign. Motion prevails, and the amendment is adopted. We are now on the A35 amendment. Oh, God bless whoever sent this over.
Chair Mariani, that one is my amendment. I got that.
Representative Poston, you sure you don't want to wrestle him for it? Representative Johnson moves the A35 amendment.
Chair Mariani, members, this is a House File 266 that allows municipal governments to run federal background checks on businesses. I'm hoping that all of you received a letter from the Lino Lakes Public Safety Department memo. In fact, the Chief, I believe it's Swenson, is here to testify if needed. This is an important issue. He had a incident in his district where a business was granted a permit to operate, and where if we would have been able to run the background checks through the BCA, that business would not have been allowed to operate. He would have been in violation of our current laws. He would not have been provided a license. I believe, if I remember correctly, it was a massage parlor. If it's okay with the chair, I'd like to have the chief who is here be able to come and talk about this issue, because it is an important issue. I have talked personally with Superintendent Evans earlier tonight, and he does not have any issues with this bill or his amendment.
Representative Johnson, can you, so this was a bill that was introduced, is that correct?
This bill was introduced earlier this year. It was House File 2066. Unfortunately, did not get get a hearing, but it is an important issue. It's important for the safety of the citizens of Minnesota.
And Representative Johnson, this language looks like it's language that ought to make a stop at government ops. I don't know if it was referred there or not.
It was not heard there. It ended up getting moved on the floor to your committee, but unfortunately you didn't have a hearing.
Okay. Oh, boy. Representative Johnson, I think you may well have something that we should be considering. I'm frankly very hesitant, members, to take up a bill that pretty clearly should have made a stop at government ops You heard the debate today on the floor on a bill that actually everybody liked also, that arguably should have stopped the government ops. I don't think everyone got a really good answer for that. So I'm really hesitant for us to move on this. It seems to me that this is the kind of work that we can certainly take up in the next year as we put together our policy bill. And so at this point, Representative Johnson, I'm going to find the A35 Amendment
Chair Mariani?
out of order for its lack of not stopping government ops. Representative Johnson.
I understand that. I would like you to give the opportunity. The chief did come down here, and I believe
Why
he
don't we
is
do that?
still here. Let him talk about the issue.
Yeah, please come down, sir. And my apologies to you, Chief, as you come down. Procedure, we're not always perfect here, but when it's caught, we try to get it right, and it actually avoids big headaches later on as the bills continue to move. But please, sir, welcome to the committee. If you can keep your testimony brief, but you are more than welcome to share your thoughts with us this evening.
Thank you, Mr. Chair, members of the committee. Tonight, we were simply seeking some additional language.
And I'm sorry, Chief, if you can give us your name for the record. I apologize for the interruption, but it's an important formality that we do for the record.
John Swenson, I'm the Public Safety Director for the City of Lino Lakes.
Thank you.
Mr. Chair, members of the committee, we were seeking some additional language to Chapter 299C, which would authorize a national criminal history check on certain business licenses and certain applicants for employment with municipalities or local jurisdictions. Current law in Minnesota does not afford local jurisdictions to do anything but a state criminal check. We had an instance recently in Lino Lakes where we had a business applicant for massage therapy. Everything came back clear on the state checks. Had we been able to do a national check, we would have found arrest for prostitution, which we later found during a subsequent criminal investigation when we were in the process of shutting this business down. This was a business that had sprawled throughout many communities in Minnesota in the metropolitan area here, and is just something that we're seeing a lot of currently right now, are these types of businesses applying. Since our denial, or since that happened, we've had 6 other applicants that have come in, and all of those applicants show a history outside of our state, and we're not able to find out if there's any criminal record there.
Very well. Are there any questions for the chief? Representative Johnson.
I don't have any questions for the chief, but I have a question or a comment for the chair. This is a serious issue. We're dealing with sex trafficking. I would ask that you reconsider your out of order, and I will be glad to stand up on the floor to defend it, not go into government operations, because this is a huge public safety issue.
Representative Nash.
Thank you, Mr. Chair. I would echo that as a former mayor. These were concerns that we discussed in council work sessions quite a bit. Not having any ability to find out anything beyond the borders of Minnesota for businesses that we're looking to locate. And also in speaking to my now former sheriff, there were questions, again, with a massage parlor that was located in Carver County, that this could have prevented something like that from happening just by being able to look beyond the borders of the state of Minnesota. So I would urge, as Representative Johnson said, for you to reconsider and that we adopt this amendment.
Thank you, Representative Nash. Members, I do hear the seriousness of this. I also, quite frankly, do not want to jeopardize the rest of this bill, and I appreciate the offer of advocacy on this. But you can hear the hesitancy in my voice on this. Representative Dean.
Thank you, Mr. Chair. And as I'm thinking about this, as mentioned, this should probably go through government operations. And I just want to ask him some questions about schedule.
Please.
I mean, it's possible for this bill to get a hearing in GovOps, be re-referred to our committee, and then we at some point could incorporate this back into the omnibus bill before it gets to the floor, or even before Ways and Means. Am I understanding our process in a way that we actually could process in a way that there would be no doubt and no question that we did it the right way?
It'll take a little elbow grease, but I think if we can work bipartisanly, we might be able to pull that off. Representative Johnson.
Chair Mariani, I think I have a path for you. Right now, this committee is in possession of the bill. We can send the bill back to GovOps, but we can still at the same time, at this moment, add this amendment on, have GovOps hear the bill as soon as they can. And by the time Ways and Means hears this bill, it has already been heard in GovOps.
Well, Representative Johnson, you and I talked about coming back on Tuesday because we thought that there was an amendment that wasn't properly posted. It turns out that as we look carefully, we think it is properly posted, but I kind of like the idea of coming back on Tuesday, make sure we can clean things up and get the bill out as clean as possible. And so we could, one, we could spend a little time, give ourselves a little bit of time to figure out a good way to move a good policy forward without getting a technical problem here. It could well be that we can move. I think we can do a number of things. We could either move the bill, since we have possession of it, out on Tuesday, and then to your point, work to get it onto the bill at some point. I don't have all the pieces yet, but I'm willing to work with you on this. Well, that's true. We could also do a floor amendment. Right. We have to make sure that GovOps hears this bill. Anyone here on GovOps that can help with? A couple of us. Wonderful.
I believe didn't she announce that they're going to have a meeting on Wednesday?
State government. Local and state government.
Oh.
All right.
Not.
So why don't we figure this out? If you would be so kind as to withdraw the motion on the amendment. We've got on the record that we're going to work creatively and together to move, but I think it's an important piece of legislation. Representative Johnson.
Chair Mariani, basically we pretty much have heard the bill here at this time. The bill is in our possession. I'm just wondering if we could take a motion to re-refer that from this committee over to GovOps right now.
Yeah, I'm a little worried about that. We haven't posted the bill to be heard today.
We are not taking any action, just sending it back to GovOps.
We can do that without an actual action. No, but we have the bill.
No, we can take, Mr. Chair, I think what Representative Johnson is, since we have House File 2066 in our possession, we can make a motion right now to re-refer it out of our committee to government operations. That would then put it in government operations possession. They can act on it, and when they act on it, it can come back to us.
We can.
We haven't had any public testimony.
I love this creative process.
I don't.
Mr. Chair,
Representative O'Neill.
if you don't want to have recommendation, you can actually make a motion to refer without recommendation. Yeah, and then it's just a referral without any up or down vote.
All right. So in other words, the chair would just do that.
Thank
Representative Pinto. We did that before.
You were first, right? Councilman actually.
Well,
I'm
this
sorry,
isn't
Chair
a bill, this is
Considine.
an amendment, and
Right.
we'd also pretty much have to have public testimony, I believe. Just,
Yeah, I don't.
Mr. Chair?
I love this.
Mr. Chair, yep, I don't see how it would be proper to refer an amendment that we are considering to a bill to another committee. If the bill was before us, then perhaps we could do it, but the bill is not before us, the amendment is.
Mr. Chair? Just for clarification,
Who's got the
I
football
believe,
game going on? That's what I want to know.
if my understanding is correct, the re-referral is not referring to the amendment before us. It would be after we pass or take action on the underlying omnibus bill that we're discussing. A motion could be made to re-refer the actual bill to, without recommendation, so therefore public testimony not required, to the committee in question.
Mr. Chair, actually, that's my motion.
Representative Dingell, hold on. Hold on, let's dial a friend with our House research here. House counsel, in terms of being able to refer a bill without recommendation, what would be the simplest path, and whether or not you know that's a violation of our House rules?
So,
Mr. Chair and members, we'd have to ask our boss. He's the parliamentarian.
Okay, call him up. No.
Thank you, Mr. Chair. So it seems like, if I'm understanding the idea being that once we've acted on House File 2792, we're all done at the end of the night, whenever that is. You, the chair, I suppose, could add this bill to our agenda, which essentially, that's the only way we'd get it before us, and then we would then move to refer without recommendation. I'll note that it wouldn't have been posted. I mean, it would just be, you just add it at that point, and then the bill would be before us, we'd make a motion. I'm trying to think of any other way that it would happen otherwise.
Mr. Chair.
Representative Miller has another option.
Well, they're all on the table right now, right? Mr. Chair, we've seen other bills on the House floor be requested that it be taken from, there's a motion on the floor to take a bill from a committee and re-refer it to another committee. He could do that on the floor, and if you stood up and said, sounds good to me, we probably would be able to do it. Tomorrow. Tomorrow.
We can send it over tomorrow.
Yeah. Not as dumb as I look.
Mr. Chair, I withdraw my amendment.
Thank you.
My proposal, my motion.
So that's in there. If the bill is heard.
If the heard bill is heard, so you can re-refer it.
This is coming together, folks, so. So we're gonna come back on Tuesday, so we can lay this amendment over, right? In the meantime, tomorrow we can have the bill.
Just moved over.
Yeah. Moved over, gets before GovOps. We got to still work GovOps on this issue. And then, right, and then we'll bring it back as an amendment.
You said welcome the amendment.
Yes, right.
Of the House. Okay.
All right, so I guess at this point, we're going to lay or table the A35 amendment. Withdraw easier?
I'll withdraw the amendment and to bring back up at a later date, and I want to thank the chief for being here.
Chief, thank you so much, and I apologize we had to witness our apologies. All right, so the A35 amendment has been withdrawn, and we're going to work to make this thing happen. The A38 amendment?
I've got that one, Mr. Chair.
Representative Grasso moves the A38 amendment.
Thank you, Mr. Chair. The language here is from House File 2250 that requires special license plates for level 3 predatory offenders. We have DUI plates for DWI offenders. Predatory offenders are, I believe, special level 3, most likely to recidivate. So I just want to ask for your support. This bill, this bill was brought forward by a friend of the Wetterlings and a well-known reporter. And after Jacob's body was found, in hopes that it would help prevent these types of things from happening again to someone else's child. While assisting Representative McDonald with this bill, Several stories were on the news. One where a registered offender got onto a school bus with the children. Drew Shadeen, if you recall that case, was abducted, raped, murdered by a registered sex offender. Met and spoke with a young lady just recently who came to the Capitol here, and she told me the tale of being abducted, raped, but she escaped from someone who was a registered offender. And like I said, we put DWI plates on vehicles, and I don't know why we shouldn't do a similar thing with registered level 3 offenders.
Representative Grasso, this one also poses a problem not unlike the problem that we just, I think, problem solved, except I don't think we're going to be able to problem solve this one in this legislative session. You've got a rulemaking authority provision on page 5, and I'm also told that this will need to make a stop at Transportation Committee. So we got 2 committees here with GovOps. I think maybe this is, not maybe, I think this is one we're going to have to work on for next year. Because given that reality, I really have no other option than to find this amendment out of order. Representative Lucero.
Thank you, Mr. Chair. I just want to take this opportunity to briefly remark on something that's germane to this, and I was hoping that we would be able to amend this. We found out earlier today, the Star Tribune was reporting that there are 3 sex offenders moving to the city of Dayton. And one of them, after murdering his wife, was convicted of raping 2 teenagers. The second raped a 12-year-old girl and later admitted to molesting a 3-year-old girl. And the third was convicted of 3 separate cases of forcing women into sexual acts while threatening them with weapons. The members of my community are extremely upset right now. And it is this bill language that would help members of my community to maybe give a kernel of comfort and at least knowing if people like this that are potentially going to be traveling the community in proximity to their children, their grandchildren, there's just a lot of concern right now. So thank you, Mr. Chair.
Thank you, Representative Lucero. All worthy and important facts and issues for us to address. I've now been pointed out that with a petition for judicial review, looks like this committee, or this also may need to make a stop in judiciary. And so Representative Grasso, I would suggest you withdraw the amendment, and we can work on this for next year and make sure that it hits all those committees, and that we could have a good, healthy debate at that time.
Okay, Mr. Chair, I'll go with your route there. I thank you for, and I look forward to working with you on this further. So I will withdraw this motion or this amendment at the time.
Thank you, Representative Grasso. Let's work on that together in the interim. Members, the A39 Amendment.
Mr. Chair, that's my amendment. I would like to move the A39.
Representative Poston moves the A39 Amendment. Representative Poston.
Mr. Chair, members, the A39 requires all the nonprofits who receive direct or pass-through appropriations through the Office of Justice Programs to provide a financial report on their expenditures. And I think it's important for us to find out how taxpayers' money has been spent. With that, I just ask for your support.
Representative Poston, boy, you guys kind of I guess I clumped them all together. We did a very quick check. We could certainly have OJP come down and speak very quickly, but it looks like this is going to cost them some money.
I'm sorry.
It looks like this is going to cost them some money that And obviously, the amendment is not addressing that issue before us. We can certainly have them come down and testify if you want to hear that, and so my recommendation would be to pull this amendment as well. Otherwise, well.
Mr. Chair, I'm not sure where the cost comes from, because this is the nonprofits reporting to the OJP.
Well, Ms. Weeks, if you can come forward. I'm breaking all my rules here. They're not rules, they're guidelines. There we go. Yeah. That's right. Guidelines. Ms. Weeks. Or Director Weeks, I should say.
Good evening. My name is Kate Weeks. I'm the Executive Director of the Office of Justice Programs. I was communicating with our staff earlier today, kind of looking at this amendment. It will cover approximately 200 of the grantees that we oversee, and it would take staff time every year to pull this information together in a report to submit to the legislature. And so that is just it will take time, staff time, to do that work, and so that does have a cost. The other thing that was raised is the timing of the amendment for when the information would be due. A lot of this information doesn't come in until December 31st, end of the year information, and so that is a tight turnaround time. Another point that they raised.
Director Weeks, I'm just curious. I do like the idea of whatever we're appropriating to all across the government and whatever policy that we're promoting to be able to receive, assessments back, evaluations, sometimes quantitative data, about the impact of our decisions here. Well, let me just ask it straight out. Is there something like that obviously not this, because this calls for all sorts of detailed work, which I think is part of the people power that's going to be required here. But does the office provide that kind of either periodic or let's say periodic assessment of evaluation information back to the legislature on, particularly on its grants, its appropriations for grants?
Chair, members, I don't believe that we have a formal report that's similar to contemplated in this amendment, but we do look at metrics. We do look at we do work with programs on evaluation, who are you serving, how many people, what services are you providing, how are you doing outreach. We do monitor all of that. A lot of that is in our grant guidelines. It's in the grant manual. There's a lot of federal requirements around capturing that information as well. So we're more than happy to have information about what is the best way to provide this information for you to review. We're definitely open to having those conversations, what makes the most sense.
Very well. Are there any questions for Director Weeks? Representative Pinto.
Thank you, Mr. Chair. As I look at the amendment, I see it's referencing grants issued to nonprofit organizations. I'm just trying to think through, because a significant number of grants go to other than nonprofit organizations, so city, county governments, even potentially other state agencies, depending on the nature. It's quite a lot. I guess maybe just if Ms. Weeks can just confirm that or just provide a sense, because it seems like a pretty significant proportion are going to recipients other than nonprofit organizations.
Director Weeks.
Chair, members, you're stretching me without my phone a friend. No, I'm just kidding. We do, like we talked about yesterday, the state funds that we receive do go to nonprofits covering crime victim services. We do have grants going for victim advocates in prosecutors' offices throughout Minnesota. We do have grants going to law enforcement. We do have grants going to community organizations. We do have grants going to other state agencies or divisions within the department. So it is a wide variety of grantees that are outside of a traditional nonprofit organization.
And
Representative.
thank you, Mr. Chair. And so a quick follow-up. I know that that then recipients have to provide a report on how they've used the funds. the work that I'd done, the statewide sex trafficking work was at the time, a number of years ago, through the Office of Justice Program, and I know that there's that the recipients have to provide a report. I guess the question is, what's the best way to have that information then be transparent to both policymakers and the public, right? Not just, and so it does seem to me that this would impose a pretty significant cost, and one that may well be worth paying, but we just have to think through the best way to do it, and what else we cut or adjust to do that, which this, I will note, the amendment itself does not do. Thank you, Mr. Chair.
Thank you, Representative Pinto. Are there any other, Representative Nash, then Representative Johnson.
Well, thank you, Mr. Chair. It'll surprise no one that I believe that there's an IT solution in here somewhere. My question to Ms. Weeks is, in your financial software, is there not a field where you flag what the nature of these grants are when your people who are dispersing funds disperse them? I got to believe that there is. So as a result of that, reporting out of a relational database shouldn't be overly cumbersome. If you revert back to the nature of what was inputted into the database, to quote my friend Representative Lucero from one of his more brilliant floor speeches, a database with good data is meaningful. So I got to think that in your reporting software that there is something that you're flagging in there that makes the data vital and integral to something that's like this. Is there such a thing?
Director Weeks.
Chair members, it is my understanding that we do use a system called eGrants, and so we do have a system that is tracking and monitoring our granting process. I cannot speak to what that looks like right now, but I can definitely go back and talk to our staff about the intricacies of that program.
Mr. Chair.
Representative.
Thanks, Mr. Chair. Well, again, I got to think that something that is dealing with grant monies that have more regulations than this committee is probably aware of in how they are dispersed, that there's somewhere in that database that forces compliancy with that. So I think that it's not untoward of us as policymakers who cut checks to ask for that level of granularity. And I would imagine, based on just compliance alone, that you would have been forced to put that in there to start off with. So I would hope that we could actually move forward on this and do this, because I gotta bet. I'll bet all the money in Representative Lesch's pocket right now that data's in there.
Well, that opens up a whole nother conversation. Representative Johnson and Representative Dean.
Chair Mariani, members, Ms. Weeks. Actually, if you read the amendment, it just deals with the nonprofit organizations under this subdivision. So it just deals with the ones that we're funding this year, or actually in the rider language. So I think it's only 3. It'd be a good test to see what information we get. This is something that we've never done. I think, as the chair says, data is good. Data will find us if these projects are working, if we should continue them. So I think this would be a good test and a good amendment to test, see how things work and make sure that the funding we're doing is going to the proper place.
Representative.
Mr. Chair, I don't believe that this amendment addresses the presentation that we had from 3 organizations yesterday. And if it does, I'm very, very concerned about this, because those presentations were regarding efforts in our African-American community. And I would just be really, really upset if all of a sudden grants that are going to the African-American community are going to be held to a different standard than other grants. And I'm not going to go there. But what I do want to say is, we have agencies, clearly, they have metrics they go by. We grant funding, and I think in some ways, there's that trust but verify, and I think this is going beyond but verify. And I, originally got on the list to apologize to Director Weeks that we've kept you here till 10:15 tonight, because we've had several amendments that regard OJP. And I'm just, I can't wrap my heads around that you presented yesterday. Or was it today? No, it was yesterday. And now all of a sudden we got 5 or 6 different amendments that say we have no trust in OJP. Well, I want you to know that I have trust in OJP. I've seen the work that, the department's done over the past several years. I think it's critical work. And with that, Mr. Chair, I'll conclude my comments.
Very well. Members, are we ready to vote? Representative Johnson.
Chair Mariani, these deal with medical center, or no, domestic abuse prevention grants is what they deal with. That's the area. I'll get all of them. Domestic abuse prevention grants, youth intervention programs, and domestic abuse transformation programs. Those are the 3 areas in the bill that this rider does. They all are, as far as I can tell, none of them are set up to be earmarked. They're open grants. Anybody can ask for these grants. It's all the grants, the 3 areas that we have. It's not targeted to any one person. We need to find out if the funding we're doing is going to the proper place and that the programs are working.
Mr. Chair, if I could just respond quickly to
hold on. Hold on.
No, you can let him go first.
Is that okay?
Yeah. Well, I mean, and I apologize if I misinterpreted your 3, but it seemed to correlate, unfortunately, to the 3 presentations we had yesterday. So if that was not your intention, my apologies.
It was not my intention.
Thank you. Thank you both. Representative Lucero.
And I think even related to that, what I was just going to briefly follow up on was, I don't think these amendments are related to a lack of trust by the OJP. It's they would be more appropriate in other departments administering or under their purview. So that was the intent, at least in my discussion with the amendment authors on those related to the office. Thank you.
Members, we're going to vote. I think there's, in the chair's opinion, I think that there's some important values and objectives that this amendment speaks to. However, quite frankly, members, I think that we ought to have this conversation within the broader scope of the appropriations that we're making, and not just singling out OJP at this point. And so I'm going to encourage members not to support this amendment. Representative Poston, you get the last word.
Thank you, Mr. Chair. This isn't anything to do with trusting the department. This has to do with transparency. And I think Representative Pinto is absolutely right. There should be transparency in reporting back to the legislature, and it should be public as well. These grants are funded by taxpayers, and our taxpayers are asking more and more how their dollars are being spent. And that's what this is all about, transparency. And I think 3, to start with as a test, as Representative Johnson said, would be a really good idea and would have virtually 0 cost, because again, it's these nonprofits that are preparing a report to go back to the department to come back to the legislature. I just don't see that there would be a lot of cost involved in this.
Very well. Members?
And quite honestly, Mr. Chair, I think we should do a lot more of this in all areas of state government.
I agree. Members, we're ready to vote. All in favor of the A39 amendment, please say aye.
Aye.
Opposed, same sign.
No.
Motion does not prevail. The amendment is not adopted. The A41 amendment.
Mr. Chair, that would be mine.
Representative Johnson moves adoption of the A41 amendment. Representative Johnson.
The A41 amendment reappropriates money for probation's pretrial services and provides grants to Sentence to Serve. Sentence to Serve, unfortunately, was left out of the budget. It's a great program. Many counties use it. It's a way for people in the local county jails to go out, do work, community service work in the community and they earn time credit while they're working. It cuts their time in the county jail, gets them out in the community. In fact, it even teaches them job skills. We had one member in my community who spent way too long on sentences served too many times, but he ended up getting a business out of it. He's one of the best tree trimmers in our community. He's got numerous vehicles, he's got lots of equipment, and he's doing very well. But it's because of sentences served that he's able to do that. It also reduced costs for the county for those in custody because it shortens their time in custody, gets them back to their families and their children. A lot of the work that sentences served does is work for the townships, for the community. They've done a lot of work in our historical society, cleaning up buildings, getting ready for events, working at the fairgrounds, cleaning them up, painting, doing a lot of work for the townships, doing brushing, cleaning the brush out of the ditch to make the township road safer. It's a very important part of our community. And unfortunately, sentences served does not appear to be funded in this bill. And I think that's a good program that needs to be funded, and I'm going to ask for your support.
Very well. Representative Johnson, just a quick question. Did you have a bill on this, on sentences served?
I did not have a bill on this. Normally, sentences served has always been funded. This is the first time it has not been, that I'm aware of.
Very well. Discussion?
Where's the money coming from?
Representative Considine.
Sorry, Chair Mariani. Where's the money coming from? Are you taking it out of?
Representative Johnson.
Representative, or Chair Mariani, Representative Corona, it's the part of the extra funding in the pretrial for services and in the probations, pretrial services.
Representative Considine, I think that it doesn't work within the current appropriations and revenues in the existing bill.
I can't. Representative Gunther had a bill, and I was co-author on it. I'm a big fan of sentence to service, but I don't know how we take it away from probation officers at this point. That's why I was wondering where it's coming from.
Very well. Members, all in favor of the
Chair
Representative Johnson, last word.
The funding that in this pretrial service is a new appropriation. You take this, you don't fund sentence to serve, and you're sentencing a lot of people to a lot more time in the county jails. You're spending a lot more tax dollars because it's programs that these people are doing, working off their sentence, that would tax dollars be used to pay for. This is a double hit to the communities, especially in greater Minnesota. Not funding sentence to serve is increasing property taxes on the cities, on the counties, on the schools. They do work in the schools to keep the costs down. Not funding sentence to serve is a huge sentence on the people of Minnesota.
Representative Johnson, it would have been terrific if we had had a bill introduced so that we could have focused on this issue, heard it, had full conversation. Probably would have been terrific if someone had stopped in my office, perhaps yourself, to speak about this issue and the importance of it in the way that it's being portrayed now. I have no doubt that we're talking about something awfully important here, but quite frankly, at 10:30 at night on the day that we're marking up the bill is not the time, in my opinion, to make those kind of appeals, and certainly make those kind of appeals within the context of the terrific work that this committee has done to fund a number of very good programs. I wish we had had this conversation earlier, members. I would encourage you at this point not to support the amendment. With that, all in favor of the A41 amendment, please say aye.
Aye.
Opposed, same sign. No. Motion does not prevail. The amendment is not adopted. We're on to the A43 amendment.
Thank you, Mr. Chair. That's my amendment.
Representative O'Neill moves adoption of the A43 amendment. Representative O'Neill.
Thank you, Mr. Chair. This comes out of the corrections subdivision again, and this is a bill that I've been working with the chair with a couple different times. We've gone back and forth to try to make the ombudsman section a little bit better. And this is one thing that I think that we had missed, and so I've come back to just point it out and hope that I can get your support on it. In the underlying bill, it says the subpoena power is for any, so this is for the ombudsman, subpoena power is for any person to appear, to give testimony or produce documents or other evidence that the ombudsman deems relevant. And it's just rather broad. And so this amendment would narrow it to say that it would be anyone who's employed by the Commissioner of Corrections or a local corrections facility, because we had a lot of issues with big broad strokes and trying to narrow it so that it was a little bit more contained. We had gone back and forth many times, and I think this just is something that had gotten missed. And so now it's back to the more narrow of the purview of the corrections division or corrections agency and local law enforcement and local jails. And so that's what the amendment does, Mr. Chair.
Very well. Chair Considine.
Thank you, Mr. Chair. And while I appreciate what you're trying to do, if you had somebody that was there as a visitor and witnessed a crime, then they wouldn't be able to do it. Or if you had a vendor that was coming in and loading up the pop machines or whatever, they wouldn't be able to subpoena and witness something that would be outside of what they could do. I think this narrows it just a little bit too much. So I would say there's a couple of things sprang to mind right away that maybe we should look at trying to narrow, but not quite this much, because there would be people in the system, doctors, nurses, that might be there for medical stuff that could potentially witness things that the ombudsman might want to talk to. So while I appreciate what you're trying to do, I think that narrows it just a little bit too much. So.
Representative O'Neill.
Thank you, Mr. Chair. Thank you, Representative Considine. Maybe it would be something that you can think about as you move this to the floor, just giving that one more look at it. I know we've looked at that bill quite a lot, so just want to make sure that it's within the right scope. So thank you, Representative Considine.
Very well.
And I'd like to say I really appreciate all the work you have done on this bill and made it considerably better than what it started out. Thanks.
Very well. Representative O'Neill, do you want to vote on the amendment?
I can withdraw it, and I'll just hope that Chair Considine works on it a little bit more and just gives it a little bit more thought. It's a bill that we've kind of come back and forth on quite a lot, so one more look at it would be good. Thank you, Mr. Chair.
Very well, thank you. And perhaps there's some conversations and work that might yet be still produced in this area. So Representative O'Neill withdraws the A43 amendment. The A44 amendment?
Thank you, Mr. Chair.
Is that Representative O'Neill moves the A44 amendment?
Yes, thank you, Mr. Chair. This bill is a very important bill to my brother, Representative Daniels, and the larger community of the deaf, blind, hard of hearing folks. My nephew, who is my brother's son, is hearing impaired, and without his hearing aids, he is really deaf. So it's very difficult for him in many different situations, and in particular when there's something that's happening that's an emergency and on television. So there was a member of the community where my brother lives, where he has quite a large deaf community there. And when 9/11 happened and the television was showing all of the visual, you can all imagine the visual, there was no closed captioning when that was happening. And it was really terrifying to the deaf community. And so this bill has kind of come from that. And I understand that, that this is in rule, but I think it's really important that we put it into law. It really would send a signal to those that are deaf and hard of hearing that we're listening to them and we care about their concerns and that we are codifying what is now in rule. And so that's why I bring this amendment forward.
Discussion? I must admit, I don't know much about this area. So we have language under rule already, and so we're moving to put in statute the current rule. Is that correct, Representative O'Neill?
Thank you, Mr. Chair. So you might recall the committee hearing that we had with the bill hearing, and you had several interpreters, and that was what they were trying to communicate, and maybe it was a challenge because most of us don't sign and don't read ASL, and I know that maybe it didn't get communicated well, but yes, it is currently in rule, and they were asking it to be codified into statute.
So what can you tell me, Representative O'Neill, about any possible costs? And I can certainly ask our fiscal staff that question as well.
Well, I can tell you that since it's already in rule, they're doing it for the most part, but this would just assure that, in fact, it is being done anytime that there's an emergency broadcast. I can't fathom that there'd be a cost, but we certainly can ask fiscal staff what they think.
We'll see if they know anything, Mr. Walz. I shouldn't say it that way. They know lots of things. We'll see if they know anything about this.
Mr. Chair, no, I don't know much, but the original bill just had a blank appropriation for this this task, and I don't recall any discussion as to how much anyone thought it would cost.
Mr. Chair, maybe we have someone from DPS if they have had any thought about this.
Okay, Representative Mariani breaks his guidelines yet again. Is there any friends over at DPS that can enlighten us on? Good evening, Director.
Good evening, Mr. Chair and members. My name is Joe Kelly. I am the State Emergency Management Director with the Minnesota Department of Public Safety. And I would like to first say that in that role, with that responsibility, I fully support that we in state government have the capability to communicate with all Minnesotans during emergencies. To that end, it was about a year ago that myself and members of the Commissioner's Office of Communications staff met with members of the Minnesota Commission of the Deaf, Blind, and Hard of Hearing when they, quite frankly, brought this issue to our attention. And we rewrote or we amended the Minnesota Emergency Operations Plan, which is the comprehensive plan that is being addressed in the language here, to not only assign responsibility for captioning, but also to provide American Sign Language interpreters during live broadcasts of emergency information. So I would state, I don't necessarily, Mr. Chair, members believe that it is in rule. The responsibility to implement this capability is in the Minnesota Emergency Operations Plan, which was signed off by the governor and the other executive branch commissioners back last August. So to the first part of the bill, that the planning part has been done, and we are now in the process of the implementation of providing the state with that capability. Realizing that a lot of the captioning that gets done is often done by the television stations. I believe, Mr. Walz, there was a fiscal note that was prepared for this, because there is a requirement, because right now the DPS Office of Communications, while they have responsibility, have been assigned to figure this out, how to do this, there is some technology that is required for them to be able to produce real-time captioning. If we are holding up a media event with the governor and the commissioner putting out information to the public, as well as the second part of the proposal, which is for all closed captioning for all public service announcements to have closed captioning. So, like I said, the department, fully supports that. We don't want anyone in Minnesota during emergency to not be informed. We are on our way to that end, but there is a cost associated with it to give the department that in-house capability to do that in real time, and not, quite frankly, not rely on either commercial services or the broadcast stations to do the captioning.
Thank you, Director Kelly. Mr. Walz?
Mr. Chair, the fiscal note is to House File 1421, and there's a request put in by the Department of Human Services for $418,000 in this biennium and $151,000 as an ongoing expense.
Okay. Members, boy, a lot of hesitancy at the end of the, a lot of tough amendments here, quite frankly. I think there's some righteousness here. I'm really encouraged to hear that the planning work has been happening, and that the department is moving toward implementation. Members, I have to tell you, with that kind of a fiscal note at this stage of the game, I would encourage us not to adopt this amendment and see what else we can do. Representative O'Neill?
I'm just conferring with my partisan staff, and he was suggesting that that fiscal note was for Human Services, not, yes? So the Department of Human Services.
Mr. Walz?
Mr. Chair, yes, it was requested by the Department of Human Services, and I haven't read through the note, but it said there was 2 FTE positions associated with the bill.
So members, it's not just the money, it's also we don't have the jurisdiction, certainly not without a conversation with them, and probably violating the budget target that committee is currently working with. I looked at their list of amendments for tomorrow, and it's like 3 times as long as ours. Maybe 4
Mr.
times.
Chair.
Representative O'Neill.
I apologize. So it was actually, that was written to Section 3, which is not part of the amendment. The fiscal note was written specifically for Section 3, and Section 3 is not a part of the amendment.
Mr. Walz, can you shed any more information and light on what you're seeing there? How do they do it without FTEs?
Yes, Mr. Chair, Section 3 in the original bill requires the Commission of Deaf, Deafblind, and Hard of Hearing to partner with the Department of Human Services to create a public awareness campaign for business.
And Mr. Chair, that's not a part of the amendment.
Representative O'Neill.
Thank you, Mr. Chair. That's not a part of the amendment that I'm bringing forward. Section 3 is not included.
So, Representative Walz, Mr. Walz, as you're looking at the fiscal note, are there no expenses related to the mandate to the commissioner and in the amendment that's reflected in the fiscal note?
Mr. Chair, it appears that in the bill, the original bill, there was the costs come from this partnership between deafblind and hard of hearing and the Department of Human Services. The blank appropriation in the bill was to develop a grant program for eligible nonprofit organizations to create a public awareness campaign for the need to have closed caption television programming and online broadcasting. What the amendment seeks to do is to have this as part of the emergency plan, and if it's something that emergency management could do without a cost, then I don't see that any of the costs in the fiscal note would apply to this amendment.
And yet, members, we heard from Director Kelly that he anticipates some costs, and we just don't know what that is. There is no date. So, Representative O'Neill, I'm really hesitant to recommend that we do this as much as I like it, because I'm not sure I know what I'm stepping into, what we're stepping into here in terms of costs. Is any other comments, advice, discussion?
Mr. Chair, I'm wondering if the director could be more expansive on concerns about cost. He was sort of vague.
We can certainly ask him, although I think what he testified was that he feels that there is cost, but was not certain what that would be at this point.
Thank you, Mr. Chair. Sometimes agencies, if it's important to them, they absorb the cost.
I get it. I've had more.
It's really important when you want closed captioning for people that are deaf.
I get you. I do. I've already had a couple conversations with Chair Carlson over things that he's kind of yanked me back already. Representative Nash.
Mr. Chair, we all asked to be on this committee because we value public safety. And, some of the amendments that have come out tonight, you guys know why you got them. There was design, but this is a good amendment. I mean, if we're not going to provide public safety services to people who can't hear, why are we here? Why are we on this committee? This is something that we should just do. It's just, and Mr. Chair, I think that you as the chair, I mean, you set the tone from day one. This is about making Minnesota a better and safer place. This is going to help, so we should do this. And I don't know if we have requested a roll call, but I think I will.
Well, Representative Nash, if in fact, it seems to me, if in fact we're not talking about a fiscal note here, there's plenty of time for us to figure that out and then take subsequent action. I don't think there's any disagreement, or at least I haven't heard any disagreement here about the objective here. I just want to make sure that we're moving consistently with integrity relative to the appropriation decisions that we've made to date. And I already heard a 418 figure. I understand it's connected to Section 3, but that certainly gives me pause to make sure that we're not jeopardizing other elements of the overall bill. Representative Pinto and then Representative Miller.
Thank you, Mr. Chair. Yeah, so I guess I would agree that I haven't heard any disagreement about the desirability of moving forward with this, but we've had testimony that there's a positive cost and we just don't know what it is. And so I guess it seems like, and the amendment itself doesn't pay for it. And so I guess I'm just thinking maybe the thing that makes sense is to figure out what that is, other than at 10:45 now, I guess, at night, and to talk to the department and have a conversation about it, and then assuming then whatever the cost is, then we can figure out how it would be accommodated in the budget at the right time, and then I would think whether that happens on the floor or whatever else. I'm just concerned that if we put it on with a positive cost, then the question becomes, then it gets us out of balance, and where did that come from? But again, I haven't heard any disagreement about the desirability of moving forward with this as a concept. We just have to figure out what the cost is and how to pay for it. Thank you, Mr. Chair.
Thank you, Representative.
Mr. Chair, that was actually my suggestion too. We can get a fiscal note on this, and if there's place for it, it can be offered as a friendly amendment when this comes to floor debate.
Indeed, Representative Lucero.
Mr. Chair, to that point, my concern is on the floor, if it doesn't have a fiscal note, it can be ruled out of order because you can't expand unless you reshuffle existing funds within the bill. And so that's my concern. If we don't do it now, we probably can't do it on the House floor.
Representative Lucero, there's also the possibility of doing something in Ways and Means. Although, again, I've already had my conversation with Senator Carlson once or twice, but it's important enough I'd be willing to do that. Representative O'Neill.
I just want to say thank you, Mr. Chair, and this is really important to the deaf people here, and closed captioning is incredibly important. And I think it's a really good move to make this law. And it just demonstrates to all the deaf people here that we do really care and that we take them seriously. So thank you.
So, members, right now where we're at is that there's a motion to adopt the A44 amendment. The chair's posture is that we don't do that at this point. There's also been a request for a roll call, I believe. And so, is that how we want to proceed, Representative Pinto?
With that, I mean, I guess as long as we're going there, since there's a cost and it's not funded, it seems like it would be out of order then in that case, Mr.
Well,
Chair.
that's what I was hoping to avoid having to do. Because if there's a way to salvage this, I'd like to do it without prejudice of a decision here today. Yeah, quite frankly, the amendment's not going to go on, members. And so let's not prejudice the amendment. That'd be my advice, Representative O'Neill.
Thank you, Mr. Chair. I wouldn't want a negative vote for that. I don't think that's helpful in this case. And this is something that's incredibly important to the community. They spent quite a bit of time and effort and energy to present this to us. And this was one of their major asks. And if we could just remember this as we move forward, and if there's any possible way we could add this on the floor with your blessing, we would love to do that. I got a note from Mr. Walls, and there may be other funding possible ideas. And so as we've been creative all evening, I just ask for your remembrance as we move forward, and just remember the deaf people and that they really do need closed captioning to be safe.
And perhaps we can even do this in Ways and Means before we get to the floor. Representative O'Neill, are you withdrawing the A44 amendment?
I will withdraw it with, and I will work with you as
You
we
have
move
my
forward.
commitment to work with you on this. Thank you, Representative O'Neill. Members, the A45 amendment. Is there a maker of a motion for the A45 amendment?
Oh, A45. Thank you, Mr. Chair. Yes.
Representative O'Neill moves adoption of the A45 amendment. Representative O'Neill.
Yes, thank you, Mr. Chair. This is the Cannabis Task Force appropriation, and right now it's with OJP. I thought most of these things should be in the BCA, and so we moved it out of OJP to the BCA, where I thought that was more appropriate for them to oversee that, but that's what the amendment does, sir. Chair.
Representative O'Neill, this speaks to a bill that I am carrying, and I would respectfully ask members not to vote for this. I think the OJP locus is the proper place for this. You know, there is an element of sort of sensitivity to the broad collection of people that we've brought in support of the task force. We were balancing a lot of issues here. And quite frankly, our goal was that the task force would be residing at the Department of Health. There was an agreement from a number of law enforcement entities who were pretty clear, you remember the testimony, were pretty clear that they weren't supporting legalization, even though this bill is not about legalization, but it certainly raises that issue. At the same table, we had members who were very much advocates for legalization of cannabis. They were supportive of the task force, and one of the things that that provided comfort to both those ends of the continuum was that the Department of Health be the place that would be the convener. Because of actions, or perhaps better said, inactions, although I guess it's actions on the part of the committee that has jurisdiction over health, we weren't even given a hearing in that finance division, even though this chair had offered to have us carry the costs. So that's kind of how it goes in this place sometimes. So it's back here. You know, I'm going to have to do a little bit of work to get the confidence of folks along that broad continuum, to have the commissioner Public Safety be the convener and the locus, and so OJP really speaks to that non-enforcement side, if you will, of DPS that would cause concern to a number of advocates on this. Moving it over to the BCA, I think, would move us farther away from that comfort level. It's just really a matter of perception and trust and ownership over a broad, diverse group of players who surprisingly are willing to work together. And I don't want to disrupt that balance, and so I would respectfully ask members not to vote for the A45 amendment.
One last thing, Mr. Chair, before we vote. Thank you, Mr. Chair. And so one of the more recent times I was at the BCA, ironically, I was there for a long presentation about the marijuana impacts in Denver. So that's kind of the impetus behind this too, because I know that they've already hosted that, and Department of Health was there, and experts from Denver, from Colorado, were there to talk about the impacts of marijuana on their state. And so I know that, they've literally already done it. They've had this conversation there. So that's why the move from OJP over to the BCA. I literally have just was there a few months back talking about this very issue. So
Very well.
Mr. Chair.
Thank you, Representative O'Neill. So members, all in favor of the A45 amendment, please say aye.
Aye.
Opposed, same sign? No. Motion does not prevail. The A45 amendment is not adopted. A47 amendment.
Thank you, Mr. Chair. That is also mine.
Representative O'Neill moves adoption of the A47 amendment. Representative O'Neill.
Thank you, Mr. Chair. And this is back to a conversation we had much earlier in the evening about the, the task force that you had put together, not task force, the indeterminate sentencing release board. That's what
Everyone
it's
wants to say intermediate.
I know, indeterminate. And just requiring that they be judges, which is in line with what we do when we do the civil commitment release of sex offenders. It's modeled after that. And so I would have a little bit higher comfort with folks making decisions that had already served as judges. I've served on many different advisory councils and advisory groups with some fantastic judges. I won't name them because they might be listening, but hopefully they're not listening already, but they are just incredible resources. Some were former Supreme Court justices and other areas as well, but they are just incredible resources to the state of Minnesota, and that's why I bring forth this amendment.
Representative O'Neill, we did have this conversation. I would respectfully ask members to not adopt the A47 amendment. This would preclude a diversity of other experts to be able to participate on the board. We may very well want individuals, for instance, who have deep experience and knowledge and formal training in a clinical way and working with offenders, residents of our facilities. So the idea here really is to cast a broad net of top quality experts that can bring strong perspectives, not just from the judicial arena, although I think that's as important as well, and certainly the language as exists would allow for judges, including retired judges, to sit on the board. And so I would ask members not to support the A47 amendment. Discussion? If not, all in favor of the A47 amendment, please say aye.
Aye.
Opposed, same sign.
No.
Motion does not prevail. The amendment is not adopted. The A15 amendment.
Chair, the A15 we're not offering.
Okay, A15 will not be offered. The A18 amendment.
That's mine, Mr. Chair.
Representative Nash, moves the A18 Amendment. Representative Nash.
Mr. Chair, sort of a conversation around what Representative Edelson had said earlier and a personal story as well. School resource officers, school safety is very, very important. Recently, the Waconia 110 School Board made a decision to not fund their school resource officer because they are in a deficit position. And that, as a parent of kids that are in that school, is very, very concerning. So we've drafted this to appropriate $250,000 each year from the proposed Peace Officer Excellent Task Force and direct that towards schools so they can keep their school resource officer. This is pretty important, and I would hope that I could gain your support.
Very well. Thank you, Representative Nash. Representative Howard.
Thank you, Mr. Chair. And I just want to speak to where this funding is coming from, the Police Excellence Task Force. We had a very positive hearing on that bill this session, and it's, I believe, really important work to move forward this year, so I'd speak against the amendment.
Very well. Representative Dean.
Mr. Chair and members, I'm not doing the math in my head probably too well at this time, but I think that when we look at $250,000 each year, I think probably the most it would get us is probably 2 school resource officers. And I would question how we would actually sort of allocate those resource officers throughout the whole state. So I'm really concerned that we're in essence taking money from one program that's to look at one thing, and we're now beginning to say that we want to fund 2 positions statewide, and I just think that that's problematic.
Mr. Chair.
Further discussion, Representative Nash.
Mr. Chair, in speaking to, as again, former mayor, I used to negotiate the contracts. School resource officers very often are shared by a municipality. So when they are not in the school year, the municipality bears the cost of that. So it's essentially a half of a school resource officer. The school district then bears the other cost. That's exactly the model that was being done in Waconia. It's the model that's being done in other schools. So it is not, to Representative Dean's question, just funding 2 school resource officers. I believe that this is a great thing that we can show our constituents around the state, and I would ask for a roll call on this, Mr. Chair.
Roll call has been requested. Representative Edelson.
Thank you, Chair, and thank you, Representative Nash. I agree with you that school resource officers are really important. Happy that we agree on something. So, but with this, I just want to let you know, so I'm on Ed Finance, and we're really prioritizing funding, school safety grants, school student support grants. We have a 3% and a 2%. So your school district will be getting dollars that I think that they'll be able to shift around, hopefully. Now, again, we don't know what the final amount is, and it's definitely probably not going to be what we think. But in terms of this, there will be dollars. And I think that they could probably figure out maybe some tweaking of where it could be between the student support grants and the school safety grants.
Representative Dean.
Thank you, Mr. Chair. And even if we're talking about funding of half of a school resource officer at sort of half of that cost, we would move from 2 to 4 positions. And again, I'm still really concerned that we're talking about funding for school resource officers throughout the state of Minnesota. And I have no idea what that process would look like on how people would compete to get that funding. What Vice Chair Adelson said is, currently with education, they're looking at this, and that's probably a more appropriate way of funding additional school resource officers.
Thank you. Representative Nash, on line 1.5 of your amendment, it's $250,000 each year. And the amendment deletes a one-time appropriation for the peace officer task force. Was that $250,000, Representative Howard?
$250,000, but I believe just one time.
So $250,000 for one time. So Representative Nash, since you've asked for a roll call, quite frankly, I'm going to rule your amendment out of order. You're not just going into a one-time grant to pay for the first year. You're making an ongoing appropriation that will put us over the tails target of this committee. And so I'm going to rule the A18 amendment out of order. Members, the A19 amendment.
Mr. Chair, that would be my amendment.
Representative Johnson moves the A19 amendment. And Representative Johnson, before you get too deep, I'm going to rule this one out of order as well. There's a lot of money on the table here that you're talking about, but please explain your amendment.
Well, what the amendment basically does is deletes the sunset of $6 million in the training appropriations to the post board. Training is very important. In your packets, there's a letter of support for the training and how important it is. Also an issue dealing with the private personal data collection and storage and their concerns that this information is going to a private entity and not being kept by the state. That is very concerning to me. I spoke about that earlier with one of the first amendments of the day, many hours ago. Especially with the type of data that's being collected, the officers' names, the badge number, and the fact that the vast number of these complaints are false, but it's going to be used against them. And it's going to be used by an outside agency, outside the state, a community organization that we have no control over. That is probably one of the most egregious things that this committee could ever do.
Well, Representative Johnson, I do take issue with your depiction of the proposal. I certainly respect your opinion on it, but I have to tell you, members, we have consistently talked about data collection that, quite frankly, is intended to be used by our peace officer community in order to continue to enhance the skills that they're developing, hopefully developing through the training that we've directed them to have. But quite frankly, members, and members, I mean, I'll leave it to you individually, but, I'm going to say it again. At this point, we are the only entity that is making a commitment to extend beyond the sunset the training dollars that are reimbursable from the post board through reimbursements to our CLEOs. All right? This bill actually extends the sunset out yet another day or another year. I wish, members, that we had the TAO ability, the resources to get rid of the sunset and to continue to make those important investments for a long time with our peace officer community. Along with that, just like with every other appropriation we make, we had a conversation earlier today. We couldn't quite fix the issue of the OJP, evaluation issue. I did say at that point that I think it's important for us to be able to assess all the appropriation decisions that we make. My objection to the OJP is that we were singling them out without having a comprehensive conversation of what our approach is for evaluation work. And in this case, we're making a major investment, and it's sunsetted. So someone out there doesn't believe that we should continue it. We believe we should continue it. And in order to convince those who don't, we think it's really important for us to do the kind of data collection work that the bill calls for. But Representative Johnson, this is at the very least $6 million out of our target, and quite frankly, way more than that. If we're going to not have a sunset going forward. And so I find this amendment, quite frankly, to be grossly violating of our budget target, and I would rule it out of order. Members, A21 Amendment.
Withdraw.
A21 Amendment has been withdrawn. All right, you and John had this conversation. Very well. So members, we only have the A19-0372 amendment, which was posted as the HF A19 amendment. And so this has been properly posted. And this hopefully will be our last amendment, or actually will be our last amendment today. Do we have a mover for the motion? Representative Christensen.
Thank you, Mr. Chair and members. Yeah, so I move my amendment A19-0372.
Very well. I'm sorry. I'm tired. Representative Christensen moves the A19-0372 amendment. Representative Christensen.
Okay, thank you, members. Mr. Chair. So this is a bill, actually, that comes from Ryan Winkler. Our majority leader ran the bill, and I'm getting it into our omnibus bill here today, so I'm moving the amendment. This is a bill to ban private prisons in the state of Minnesota. Reasons for that are just, first of all, I'm just going to go with the moral and ethic reasons that we can talk about, that, you know, there's for-profit prisons are usually owned by corporations, or there's shareholders in it. It's publicly bought and it's owned by corporations, and they have a fiduciary responsibility to their shareholders or whoever their investors are to make money. And so I think that goes against what we do here on this committee, that we're here to provide programming, we're here to reduce recidivism, and I just, you know, believe that the whole philosophy, the whole business, you know, the whole business reason that these are even in play at all in Minnesota is wrong, and I think it goes against what we on the committee have really worked hard for. So I'm ready for you. Yeah. Thank you.
Discussion. Representative Miller.
Thank you, Mr. Chair. And first, I'd like to ask for a roll call before I forget that.
The roll call has been requested.
And Mr. Chair, it's late. I'm going to be brief tonight. I'm going to save my broader message for when this comes to the floor. And so I have 2 points to make. First of all, Mr. Chair and members, there aren't 100 private prisons in Minnesota. There aren't 20. There aren't even 2. There's one private prison in the state of Minnesota. It's in Appleton, which is in my district. It's about 3 hours west of here. And I'll save your time tonight to give you the forward thinking that a small community did in rural Minnesota. We talk about population loss, job opportunities, young people, all this stuff, and you had a thriving community with this prison there. And it's been empty now since 2010, in part because of the efforts of people in this state, in this legislature. Not entirely, but that's been part of it. I just want to first say that I can tell you the good people of Appleton don't deserve this, okay? I've been in a position to where this bill has come up every year since I've been here. Maybe it's come before that. And every year I'm in a difficult position because I'm forced to defend a corporation that isn't in here in the state of Minnesota. Their headquarters aren't. I'm not here to defend a corporation or what they do, but I have to hear things about what Appleton Prison is like by people that have never been there. I've had to hear things that aren't true about that place, the region, the location. And quite frankly, Mr. Chair, it's just so tiring that I have to keep going back to these things. I've had, since I've been here, I've worked with the last commissioner. I'm in the process of working with the current commissioner to come up with ways that we can make this work. That's right. I represent the state of Minnesota, not just my region. And we've tried to identify ways that we can basically make this work for everyone. But when I hear an amendment that says the commissioner shall not allow inmates to be housed in facilities that are not owned, right now, Mr. Chair, at no expense to the state, at no threat to the state, for example, the federal government is looking at possibly using that. But if this gets passed and signed into law, they can't do that. And this is a 1,600-bed facility that can't be redesigned for anything else. Anyone that's toured a prison knows that prisons are prisons. That's what they are, okay? And it effectively makes out in a community that's been dying since this place has been closed. It ensures that that community is going to die. And now they have this huge just lot out there with nothing to do with it. I can't imagine that the company wouldn't even be filing a lawsuit if this was passed into law. I won't go any further down that road. I'll save that for the floor. But I want to make one second point as we close out, because I think it's actually kind of fitting that we're closing out with this point that I'm going to make. And certainly there might be more discussion. But this is the point that I want to make. Mr. Chair, you and I have had individual conversations, and I'm going to say it publicly. You've done a great job with this committee. And the reason why you've done a great job with this committee is because public safety issues are very passionate. They're very difficult. We have very opposing beliefs on a lot of the bills that we address here. The gun bills, you did a fabulous job a month or so ago, and we had them here late at night, and tonight again. You have people that are in one moment talking about very difficult subjects in this room, and the next second laughing with each other, making comments. And that goes to the credit of not only you, but the members of this committee. Mr. Chair, this bill, I don't open a new can of worms, but this was brought into this committee from outside forces. And I've taken to heart what the people of Minnesota have said, that they want us to figure it out between us and get things to work. You know, we kind of pontificate and we posturize and we get in front of the cameras and we say things, but deep down the people of Minnesota say, you know, two things. Can you work together and can not just listen to special interest groups? And Mr. Chair, I'm sorry to say this, but this amendment right here is because of a special interest group. And I'm not happy with it. I'm a little bit embarrassed for this committee by it. I understand where the votes probably have to go in this room. But I'm just asking that people vote no on this bill, because this is just not okay, the direction that this has gone. If the commissioner doesn't want to use this facility for state purposes, that's fine. If we don't want to use it this way, I've been asking the state to buy it for the last 5 years. Okay? And then I get told that I'm not trying to get them to buy it. I'm trying to sneak some roundabout way so that we can put non-union people into this position and stick it to union guards. I've had guards come into my office starting angry at me, and when they've left my office, they've said, you know what, Representative Miller, you're kind of making sense with what you're saying, and they believe me just a little bit until we get into the realm of politics again. And then 6 months later, I find out all these insults that are thrown at me and the people of Appleton that aren't true, and it's for politics. Let's get politics out of this. I do respect, I don't want to address them directly, but the commissioner has been here until 11:15 at night. And I can't tell you how much I respect that willingness. We're going to be talking sometime in the future on some of these things. But if we truly want one Minnesota, if we want a better Minnesota, which is what I've been telling people, we can't be doing stuff like this. Now, I don't want to put you on the spot with that. I do ask for a roll call, so that is putting people on the spot in that respect. I just hope we do better than this in the future. Thank you, Mr. Chair.
Thank you, Representative Miller. Representative Considine.
Thank you, Mr. Chair. This bill's not about the people of Appleton. This is about a nationwide problem of corporations getting in and taking over and building private prisons, and their business model is predicated on people failing. Their business model is based on filling up beds. And when Appleton was first started to open up, they discovered they hadn't even put sprinkler systems in. They found corridors where they weren't big enough for, or cell doors where they couldn't get wheelchairs in. They went through a number of contracts, and I've seen the videos, I'm sure you have too, of the riots and things that they had at Appleton when it was there, where they had to come in with the beanbag shotguns and things and put them down. The truth is that they do it as cheap as possible. They don't offer programming. They don't offer rehabilitation. And it's not about the people of Appleton. One of the reasons that they put it there was because the people of Appleton were a good workforce, but they took advantage of it. Private prisons are a disgusting business model that are based on and predicated on people failing. And this is a core responsibility of government to take care of the prisoners and to try to rehabilitate them. And private prisons don't do that.
Mr. Chair.
Representative Miller.
Mr. Chair, Representative Considine, I respectfully disagree with almost everything that you said in context of Appleton Prison. First of all, it was owned by the city of Appleton when they built it, okay? There was a process that went by, the Core Civic took over, originally helped manage it, and then they eventually took over. And we can disagree about the role of privately run prisons. I can tell you that there is no one out there, and I don't even buy it from the people of Core Civic that I've met, that their sole purpose is to profit off of people's misery. That is just one of the most outrageous things that I've had to put up with whenever these speeches happen, and I just don't accept it. And I go back to the fact that this bill says the commissioner shall not allow inmates in anything that's owned by them. So we have two choices. Because this means even now I know that you probably don't want this anyway, I get it's a different discussion, but even ICE can't rent it, okay, in this position. Even though ICE is renting these places in multiple places. This is taking an asset in western Minnesota and saying, you know what, you're gone from the map. And that's just stunning to me. And let's say as a state we decide that we want it not privately owned. All these discussions about riots, all these discussions about services, which by the way they did have services there, but all that stuff is gone with my bills that say either buy it or rent to own it. And the only reason why we rent to own it is so that it works out with the numbers in the state. This is the frustration that I've had with this whole conversation. And this is about the people of Appleton, okay? This is about them. Representative Christensen, if they, I know this doesn't happen, but if they suddenly said we're going to close those two prisons in your community, that'd be a problem. Now imagine a town when it was open of about 4,000, now it's down to about 1,200 and people in the area are all gone and you have all these things. Imagine the devastation of that. I don't think that cannot be ignored in what we're talking about here. So I won't run, I told you I wouldn't talk long and then I did. So I apologize for that, Mr. Chair. I think we need to have a more healthy debate on the floor. My biggest frustration in this whole evening has been the process by which this was brought into this committee. That's not your fault, Mr. Chair, and I respect you. You were very kind to me and kept me communicated with that. My respect for you even increased on that. I'll just leave it at that. I won't talk anymore tonight. I just ask for a no vote on this. Thank you.
Thank you. Representative Johnson.
Members, Chair, I know it's late. I have to agree with Representative Miller on this. But I will say one thing. If the state, as long as I'm down here, if anybody brings up sending the state prisoners to a privately run prison, I will fight them tooth and nail because I never want to go to a private run prison system again.
That's all we're talking about.
No, you don't. This bill is a lot worse. Or this amendment. I'm going to take my county. a few years ago, before we did a jail expansion, we actually had to rent a hotel to put the prisoners in. It was the good guys, the ones that are on Huber. We had to rent hotel rooms to place them. Under this bill, we couldn't do that. We had a good system. It worked for many years until we actually were able to build a jail. Under this bill, we couldn't do that. We had the Harder Hilton. It worked great. Now, I never want to go to private prisons. I don't think the sheriff's office should. I don't think we should have any jails in private prisons because the prison system is our responsibility. But as Representative Miller said, with this bill, you kill Appleton, period. The entire town, the community. INS will not be able, or the federal government will not be able to come in and use that facility. It is a beautiful facility. It's a place where we can use. There's 1,600 beds there? Right now, our system that we have, the prisons we have, are running about 98, 99% capacity. Oh, by the way, they'd only let the county jails run at 80% because it's not safe to go over that. But we're running at 99%. If you want to know why there's problems, that's one reason we're over capacity. Because when there's an issue, we can't move inmates around. You take that facility, rent it, run it by the state with state union employees, putting the programs. You can take 10 to 15% of the population out of every other prison and make them safe and still have room in that prison. And I'm on a lease to own, not only because it works well for the state, but it works well for that community. To take that out of the tax rolls, that is a huge hit for that community. But giving it on a lease to own, it gives time to get them to the community to build, get back into shape so they can take that hit. But with this bill, or this amendment, it kills it. It kills a lot of opportunities for that area. I have had some nice conversation with Commissioner Snell. He understands my feeling and knows that I want to make sure that that not only the guards and the staff at these facilities across the state are safe, but also the inmates, they get the treatment they want and they need, and not sitting and basically sitting and rotting in a county jail cell where they don't get any programs. If we released the facility and ran it on a lease to own, we could get 1,600 beds, probably cheaper than build a 500-bed facility in St. Cloud that won't fit our needs. In the numbers last time I looked at from last biennium, 2023, 2024, we'd have a good chunk of Appleton filled if we ran every facility at 80 to 85%. We need the beds to get the proper programs and to do to get the recidivism rate down and provide the services that the inmates need. I'm going to offer to start with a friend. I'm going to see if we can split this amendment.
Fine.
I'd like to split it after 2.0 and just keep the first part and skip the second part. With the placement prohibited for now until we get that worked out. Because I don't want them placed, actually, I don't want them placed in privately run facilities. But let that option go so if it works out, either us or the federal government can rent that facility. And maybe staff would see if it is splittable at that point.
Representative Johnson wishes to move to divide the amendment, and we're going to turn to legal counsel here to help us interpret where Representative Johnson wishes to divide the amendment to see if that is workable.
Mr. Chair and members,
Mr. Debo.
the proposal, I believe, is to divide the amendment after 2.19. Is that correct?
Oh,
Representative Johnson?
I got to double check this again, make sure this is how I wanted to do this. Yes, that's how I'd like to do that. Because I do not want us, the state, to contract and house and have a privately run prison.
So, I'm sorry, Representative Johnson.
And I believe that would take care of that issue. So we won't be renting or sending our prisoners to a private prison. That's what I want to make sure we do.
So the question to council is whether the amendment is divisible at that point, after line 2.19.
Mr. Chair and members, I believe that the division at that point would create two propositions that could stand alone.
Very well.
where's that at?
Between 2.19 and 2.0.
So Representative Johnson, your move to divide is appropriate technically, and so Representative Johnson moves to divide the A19-0372 amendment at line 219. So after between 219 and 2.19 and 2.20. And then Representative Johnson, which part of the amendment do you wish to take first?
I would like to take the section 19 first, because like I said, I do not want us to rent space and send our inmates to a privately run facility, and I believe that's what takes care of that.
So Representative Johnson, you want us to vote on the first part of the amendment?
Yes.
Okay, very well. Yeah, so we, what do you think about, so that's to the full. Right. So let's take discussion on the first part of the amendment. Representative Miller.
Well, Mr. Chair, and with all due respect to Representative Johnson, I'm still reading in the first, because I'm assuming that he's kind of favorable towards the first of the divide, favorable towards the first, so I want to speak to that. And I'm still reading on 1.11. It says, after the commissioner shall not allow inmates to be housed in facilities that are owned and operated, that are not owned or operated by the state, local government, on and on. Now understand that the commissioner licenses that facility. So what I read that as, and council can tell me otherwise, but what I read that is he shall not allow it to be licensed either, effectively making it inactive, just as the same as the other. And I might be wrong with that, but that's the way that I'm reading it.
So, Representative Johnson?
I missed that part of it, so it's, the way this bill is written, I don't think we can divide it to get that out of there.
Per your intent.
For what I want to do, because what I want to do is make sure that we don't send our prisoners to private prisons, but I want to be able to state to have that ability, or the federal government, to rent that facility.
Very well.
Maybe we can work on that at the next stop. I hope everybody understands what I'm trying to do.
So Representative Johnson withdraws his amendment, or his call for a division, request for a division. Thank you, Chair Dean, of the amendment. So we're back to the whole amendment, and we do have individuals that wish to speak to it. Representative Lucero.
Thank you, Mr. Chair. So Representative Miller, I've been to Appleton with you. I've been to your district. I've been to Appleton. I've seen your community. and I am strongly opposed to this. Representative Christensen, I've been on the public safety my entire time here in the legislature. And I can recall, I think it was my first term, that we exceeded the capacity of the sum total of prison beds in Minnesota. I think it was by 500. Does that? So I'm seeing some heads nod. It exceeded by 500. And the discussions back then were to build a new prison. And as a member of the Public Safety Committee, I had I had sheriffs coming in because the jails are being used temporarily and they were double booked, had double occupants in the cells. And I had correction staff speaking with me as a member of the Public Safety Committee. And then I learned about Appleton Prison. And the proposal back then, and there might have been other variations, but at least the one proposal that have been familiar with my entire time has been that the prison would be owned by private company, but everything else is run by the state of Minnesota. Operations, I heard some comments over there about the programming, that would be run by the state of Minnesota. Rehabilitation, state of Minnesota. So it wouldn't be privately run. It would simply be owned, but everything else, the staff, would be fully state employees. The exact same that other departments of the state of Minnesota lease space to house state employees. There are many different departments that are owned, a building is owned by private companies that the state of Minnesota leases. But all the operations internal to that space are state run. And I see no objection to that. Because all of this immorality that you're speaking about is not moral. Again, it just, the profits, again, what's occurring to Representative Miller's district, and is something that we should not be in support of. This is just the latest of a long string of examples that we've seen by those in the metro area, 7-county metro area, trying to impose their values to rural Minnesota and harming their community. So I would strongly urge opposing this. In fact, I would hope that Representative Christensen would actually withdraw the amendment, because your concerns are not founded with the proposals that I have been familiar with, and again, many staff and sheriff have communicated to me. So thank you, Mr. Chair.
Thank you, Mr. Representative Lucero. I must take a bit of issue with part of your comments. I don't believe it is the spirit, certainly of this committee, and most likely of the legislature, to engage in the kind of regionalism that you've inferred here. I don't see a metro area attack on greater Minnesota. I have to say this bill, quite frankly, reflects a consistent posture of paying attention to all parts of the state. And several times, actually, going out of its way to identify greater Minnesota. I know that's not the issue before us. You're speaking to this amendment, but as long as we're putting things on the record, I just want to also put on the record that the values, I believe, of the work of this committee is not about that kind of regionalism. I certainly do understand the passion that's involved in this issue and greatly appreciate it. Representative Dean.
Thank you, Mr. Chair and members and Representative Miller. I'm not likely to support this, but I do want to tell you that the gesture that I made previously, I think it might have been 3 or 4 years ago to you, I've been out to Appleton, I've seen the prison, I know what it means to the town as far as employment. Any day you want to sit down and work with a stream of funding from the state of Minnesota to bring in a manufacturer or some other group into Appleton, and create funding to make sure that those individuals who may previously been employed in the facility out there, funding to create, job training or whatever we want to call it for them. I'm there with you because I know what large-scale projects like this mean to small towns. And when it's closing of a facility like this, or when it's a manufacturer that decides that they're going to leave, it has a huge impact on the community. And another solution, I'm fighting with you for that. And we can dissect the history of how this facility got into Appleton, and I think there are lots of different philosophies what happened in the times when prisons were being opened in small towns across the country. And we can have large-scale discussions and debates whether that was a good or bad thing. I'm not here to do that today. I just want to let you know that, unfortunately, I will be supporting this amendment, but I want you to know that I am more than just available. I'm willing to, put a lot of skin in the game to try to address the situation for the people in Appleton relative to employment and prosperity as well.
Thank you. Representative Considine.
Thank you, Mr. Chair. First of all, I'm not from the 7-county metro area. This is a statewide feeling that people don't care for private prisons. Secondly, there's nothing in this amendment or the bill that even mentions the federal government, and we cannot tell them what they want to do and can't do. So if they wanted to go into Appleton, they can do it. They're not doing it because it's way out of the way. And again, this thing doesn't even mention Appleton. It talks about private prisons. That's it. So and again, when they were talking with the 500 beds, when you're talking about, the Department of Corrections looked at it, and it was because it was so far out of the way that they didn't want to do it. This is about private prisons. It's not about the people of Appleton. It's not about that facility. We don't want private prisons, and I'm hearing you say the same thing, that you don't want our inmates there. And that's all it says. Read the amendment. It doesn't mention Appleton, doesn't tell the federal government they can't go in there. It just says we don't want private prisons in the state of Minnesota.
Representative Edelson.
Thank you, Chair. And to Representative Miller, I certainly, I don't agree with private prisons. At the same time, though, I don't want you to think that I don't care about Appleton, and I care about your community, just like you. I can't remember who said I think it was you that said you represent the state of Minnesota as well, and I think that we all take that service really serious. So, to Representative Dean's point, I want to help too. So, if there's a way. Just because I'm not for private prisons, and I do want to make sure that we're helping your community.
Very well, members. Before I call on the maker of the motion, I want to see if anyone else, Representative Miller.
One more comment. Thank you, Mr. Chair, and thank you, everyone, for this discussion. I don't want to touch on everything because it is late, and I'm sure we'll have some good discussion on the floor in the future. I need to restate again, 1.11 to 1.13. So when you talk about the federal government can use it, they can't use it if this is passed into law, because the federal government will lease it, and they can't lease based on this because the commissioner licenses it. Okay? I'll stick to just a couple things because my mind's even getting a little bit worn out here. The thing that is amazing to me is the group that is putting up the most push against this is basically the public union. They're the ones that have consistently put the push up against this. And I have consistently emphasized that if this moved in the direction that we're talking about, which is when the state has the need. I've always said that if the state doesn't have a need, then we don't move forward with this. But the state did come in 2016 with a $141 million bonding bill to build 500 beds at Moose Lake, I think it was. And Rush City, you're right, I'm sorry, at Rush City. And that's when I said, hey, we have one out here. And I first of all, I questioned the veracity of some of the arguments when they keep going back to, well, we're not going to have a private prison. And again, I have the union stewards from the guards coming in and saying, well, we're not going to have a private prison. You know how terrible it is there? I know somebody that worked there and they got beat up all the time. I said, fine, you're going to be running it. No, we're not. I actually had one guard tell me, you haven't read the bill, Miss Representative Miller. And I'm like, I wrote the bill and it's like a paragraph long. So it's just the veracity of that I question. But I've gone to the unions time and again. These are 300 is what they're talking about for starters. 300 good union jobs. And when I hear statements like it's too far away, do you know that Appleton, because I brought out the ruler, everything starts in St. Cloud. Appleton is actually closer than the Stillwater prison to St. Cloud. It's only a couple miles, I think it's like within 2 miles further than Faribault. If you look at other states, most states, not all, some are concentrated like Minnesota, but most states have these prisons spread out. So it's not an undoable thing. And I don't want to make this an argument about the Department of Corrections taking this over because that's a discussion for another time. I'm going back to that this amendment was brought in here sort of with a hammer, if you will, which bothers me. But it is to continue on with this private prison. Private prisons are bad, and when we say this isn't about Appleton alone, I go back and I'll finish with this. There's not 4 private prisons in Minnesota. There is no private prisons looking to move in to Minnesota. There is one. So you cannot say that when we're talking about private prisons, we're not talking about Appleton because that's the only place where we have one. And I'll leave it at that. It probably just created more discussion. So I apologize, Mr. Chair. I promise I won't speak again.
Not at all, Representative Miller. Representative Christensen, you get the last word before we vote on your amendment.
Thank you, Mr. Chair. And Representative Miller, and you know, yes, I care about your town too. I can't believe that the numbers that you're talking about your drop in population are amazing. I mean, that's a sad thing. I do think, I don't think a private prison is going to be sustainable. I don't know if it's the kind of economic growth you're going to want to see in your town. It already closed in 2010, right? So our beds are going to be dropping. If we're doing our job here and getting less and less people to be everything being criminalized, there will be less beds that we need. So although I have empathy for the town and I can't even imagine what that is like, I don't think this is probably the best economic model for you to rebuild the town. But I do have empathy for the town. So I'd just like to say that I think we all agree on the fact that just the philosophy behind private prisons isn't what we want to go for in Minnesota, and I just hope that you vote for the amendment. Thank you.
Very well. The roll call being requested, the clerk will take the roll.
Chair Mariani?
Yes.
Christensen?
Yes.
Considine?
Yes.
Dean?
Yes.
Edelson? Yes. Crossell?
No.
Howard?
Yes.
Johnson?
No.
Flesh?
Aye.
Long?
Yes.
Lucero?
No.
Miller?
No.
Moeller?
Yes.
Nash?
No.
O'Neill? Pinto?
Yes.
Poston?
No.
Yeah.
On a vote of 11 ayes and 6 noes, the motion does prevail, and the A190372 amendment is added to the bill. Members, that leaves us with the bill as amended. I think our rules said we got to be out of here in 15 minutes. I want to thank you all for working awfully hard to put together this omnibus bill. We do have a few pieces that we've made some commitments, 4 if I remember, maybe 3. So this may still change. I look forward to working with the parties over the next few days to see if we can make some progress on that. You may come back Tuesday. Oh, that's true. So we may come back Tuesday. Be on the lookout for a message from me on that. I haven't decided yet. Certainly would like to consult with my lead here about possible hearings yet before session is over. Certainly a longer conversation about interim hearings. That's sort of my odd way of saying that I'm kind of hurting thinking that we may not all be in the same room again together for quite a while. I have to tell you, I really truly have been privileged to be with you as we constructed this bill and dealt with a number of issues. I look forward to us working together where we can. I know that things of late changed a bit, the tenor in the room. I hope that we're able to, have the fights that we're going to have going forward, and at some point come back to this table being the best who we are that I've seen many times here in the past few months to be able to continue to push good public policy for the people of Minnesota. But in the meantime, we have a House File 2792 as amended, and my hope is that all members can vote for it. And I just want to thank you for the work of putting it together. With that, open up for comments. We have 10, 11 minutes before we break the rules. Representative Johnson.
Chair Mariani, members, it's been an interesting year so far. All I can say about this bill is I'm disappointed. I think, this is my 4th term here and doing some checking beforehand. This may be the first time that this will not be a bipartisan bill. You put things on here before some of the amendments, especially 2 of the amendments that went on today. It was tough for any of my members to vote for it. We were willing to have 1 vote for it to make it bipartisan. But when you put House File 8 and 9 on here on this bill, because you don't have the votes to get it off the floor, that made it to a point where you have nobody voting for it. It was bad enough before that we actually named it, gave it a name. In this bill, you bash police officers. You don't do anything for the victims of crime. Jamal, you can laugh all you want. I saw that.
Representative Johnson, we don't need to get personal on.
I understand that, but he doesn't need to laugh. This is serious. We're talking about the safety of the public of Minnesota. Representative Christensen made the comment as we were closing that as we decriminalize more things, we need less beds. We have those laws for a reason, for the safety of the public. You do things in this to make consequences for criminal activity less. I'm very disappointed in this bill. The name of this bill is the Unsafe Communities Bill, and I suggest not voting for it.
Representative Grosso.
Thank you, Mr.
Chair, I
Chair.
also like a roll call.
A roll call has been requested. Representative Grosso.
Thank you, Mr. Chair, and we worked pretty close as far as making sure that we wanted to get things moving moving in the right direction, and you told me from the start that we'd count on us to help do that. And I think overall, though I don't agree with a lot of the legislation that's in it, especially the stuff about geared towards law enforcement, but overall, I think we all put in a lot of effort to make it a good bill, the best that we could from each of our perspectives. And I told you that there was a couple things that would turn me the other direction, and you know which ones those were. And I don't hold. You know, I know there's people higher up that are pushing those two issues, and so, you know, not liking everything that was in it, I could have still supported it until this evening, sir. So, with the contentious bills that were added on tonight, I gotta stand over here and say no.
Representative Nash.
Well, thank you, Mr. Chair. It is late. We've had a lot of debate about this bill for months and tonight for a long period of time. And I came to this committee having not served on it before with fairly open eyes and open mind to hear some of the things that were going to be brought forward. And I'll echo that there were things that were causing me to consider my vote before the gun control bills were added in. But over the period of this debate on this bill and the bills that went into this, I find it very disheartening that the law enforcement community, from my perspective, is being demeaned. I find that objectionable, offensive, and that was one of the things that was going to turn me. But then you added two very awful gun bills under the false presumption that you were going to be making Minnesota safer. It's not going to do anything. I beat the drum, and I've taken you guys out for a ride, and we'll do that again on the floor. But I just can't see how some of the things that you proposed that you actually believe are going to slow crime down, gun crime. And Mr. Chair, I've enjoyed working with you. You've allowed me a lot of latitude. Rumor has it I may be a little aggressive at times, but that's because I do feel passionately about it, and you recognize that passion, and you recognize that's okay. We've had strong disagreements. We've had some fun in the process, but members, I just think that this bill that did have some things in there that I think we all could agree on is destined for failure, because it includes now two things that are guaranteed dead on arrival over in the other body, where they wear wigs and speak slowly in these and thous. But I object to those provisions that I've mentioned, and encourage a no vote.
Representative O'Neill.
Well, Mr. Chair, I just wanted to thank you because you and I have worked collaboratively together, and you know how much I wanted to vote for this moving forward, and knowing that I didn't necessarily see eye to eye on everything, but that's how things go. And as you know, that with the two gun bills going on, that's just not something that I can do. But I wanted to acknowledge the good work that we did do, and the promises kept, and the great relationship that we have. And I wish it had turned out differently. You know, I know you crafted the bill without those two gun bills on it, and I was grateful for that. We had worked really hard on some other pieces, and also with Chair Considine, he and I had worked on some pieces that were really important for the state, and I think reviving the ombudsman is incredibly important, and there's some really good work in here, and I really wish I could give you my vote tonight, but I just, as you know, cannot. So I just want to thank you, and I have to vote no tonight as well.
Thank you, Representative O'Neill. Representative Dean.
Thank you, Mr. Chair. I want to commend you for the work the past several months. I think we have worked in a very collegial manner. I think in many ways we've had some great debates and discussions around issues. I think some of us have different perspectives. And I think that that's one of the things that this legislature brings when we consider issues. I would think that some of the stuff that we've done around law enforcement is actually adding some public safety to law enforcement. You know, we talk a lot about issues of accountability. I think we need to have accountability across the board. And I'm not going to disparage anyone on this committee. This committee has worked really, really hard. We worked in ways, as long as I've been on public safety, I haven't quite seen this level of engagement and debate that really seemed to be a concern about public safety and compassion for those individuals that are not just victims of crimes, in some ways those who have perpetrated crimes, and those individuals that we expect to help keep us all safe, our law enforcement. And I know that, you know, this bill changed a lot in the last 24 hours, 30 hours, whatever. But we also all know that, you know, this place unfortunately can be a very, very political place. And I'll be supporting the bill today. And I certainly am not going to carry animosity or angst towards members that feel that the changes that have taken place mean that you cannot support it. So I just want you all to know that I've appreciated all the work that's gone on. And like I said, I know that from time to time we've had disagreements, but I think we worked incredibly well together. So thank you again, Mr. Chair.
Thank you, Representative Dean. The chair renews his motion that, I'm sorry, did I miss someone?
Yeah.
I have 2 minutes, Chair Considine.
Real quick.
Yes.
Right after the election, I sent a letter, email out to the Democratic people, said, I'd like to be considered for chair of the Public Safety Committee. I'd like to say right now that Representative Hortman made the right choice. Oh. And I think just about everybody around here would agree. You did a tremendous job, and I'm certainly happy she picked you over me. Thank you.
Thank you, Chair Considine. Pleasure to serve with you as well. The chair renews his motion that House File 2792 as amended be referred to the Committee on Ways and Means, and a roll call has been requested, and so the clerk will take the roll.
Chair Mariani?
Yes.
Christensen?
Yes.
Considine?
Yes.
Dean?
Yes.
Edelson?
Yes.
Grossel?
No.
Howard?
Yes.
Johnson?
No.
Lesh?
Aye.
Long?
Yes.
Lucero?
No.
Miller?
No.
Moeller?
Yes.
Nash?
No.
O'Neill?
No.
Pinto?
Yes.
Poston?
No.
Yep.
At a vote of 10 ayes and 7 nays, the motion prevails, and House File number 2792 as amended is referred to the Committee on Ways and Means. Members, get some good rest. We'll see you all tomorrow. Please stay tuned for a possible meeting yet next week. I want to thank you all for your perseverance and bringing your best here today. I look forward to us continuing to work together where we can. So with that, members, have a pleasant night, and this committee stands adjourned.